H1, cell number 1. H2, cell number 2 to 4. H3, cell number 5 to 10. H4, cell number 11 to 13.
Serial number? Hearing and intellectual application. So we have passed orders on this application. Why are you mentioning for adjournment?
H4, cell number 11 to 13. Page 5, cell number 14 and 15.
Which other side, Lakshmipati? Agboda? As requested by adjourned at the request of court counsel. Yes.
Page 6, cell number 16 to 18.
My lord, serial number 18, my lords. Party in person is also online. It's being posted on 30th, my lords. It's convenient for party in person.
Yes, Agboda?
Yes,
Lordship.
18, serial number 18, 30th. 30th October.
Response on 30th.
30.
Much obliged.
Page 7, number 19 to 23.
I pay your lordships, I pay for in a matter of 19. I have already transferred the amount by online. I will produce the acknowledgement. Kindly call it on 5th or 6th, my lordships.
Filing of
Final hearing matter 19, serial number 19. I have already transferred
for the
online by
appellant?
Saturday. So
You are for the appellant.
acknowledgement. Yes,
Whom do you
appellant number
represent
2.
here? Appellant number 2.
Appellant number 2, your lordships. 2, only contesting appellant.
Learner counsel for appellant number 2 submits that he has paid, deposited the amount by e-remittance and seeks time to produce the proof. Just after 1 week. Yes.
Page 8, number 24 and 25.
25 only. Adjourned at the request of the appellant's counsel. Yes.
Number 1. Here, Antanarayanan. Here, Ashok Kumar.
You have muted your system. Yes.
R2.
You are for R2.
It's a suit for partition. Court
Why they
below
are not
dismiss.
signing the paper book? Not the matter. What is that? Is that correct? Learned counsel for the response. Here it is, a submission is being made that the parties are trying for settlement.
No chance. Yesterday I met with them. They are not inclined to settle it. It's a hopeless suit. Suit for partition. It's a baseless suit for partition. 19 parties have 80 plus parties.
What was the last day's order?
Call for the records and post the matter for hearing while admitting the matter.
Records ಬಂದಿದೆ.
Well reasoned judgment is found.
44 and 29. 1 second. TCS received in the branch.
Yes, my lord, you lordship may post it.
Paper books are not filed the order. Paper books are not. Records are received.
Paper book may not be required in view of the admissions made, recorded in the course of the judgment. Admission made by the party.
Two of us have to see the records though.
Madam, it takes a voluminous time, madam.
How much? How many witnesses are there and how much evidence?
3 witnesses are there.
One second, we'll see.
3 witnesses. Documents about 30 from the defendant side and 20 from the plaintiff side. 30 plus 20, 50 documents.
Plaint was rejected. Plaint was rejected on the ground of non-payment of required court fee.
Yes, they have not paid.
First rejected. Plaint rejected.
And subsequent order is also there. If the court fee is paid, the suit is dismissed on merits. 2 orders are there. And before this court, they have sought for a pauper suit.
PW 1 to 3, exhibit P 1 to 17.
17,
1 to 3, exhibit D 1 to D 29.
30 almost.
ಇಲ್ಲ ಬೇಕಾಗುತ್ತಲ್ವಾ? Here we record that there is no compromise. He shall file the paper book within 10 days. This is 2006 appeal. Suit is of the year 1990.
Yes, my lord.
1990, 2000, 33 years. 33 years. Correct.
33 years. Parties are 80 plus.
It is submitted on behalf of the council correspond that the parties are trying for the settlement. The council for the appellant respondent, council correspond number 2 submits that no settlement negotiations have taken place, nor response are ready for settlement. At request finally 10 days time is granted to file the paper books, failing which the appeal shall stand dismissed.
And date may be fixed, my lord.
Yes, actual date.
Date,
13,
please.
13, 10. Farah Fatima and Sudhakar Pai.
R1 ಏನಾಗಿದೆ? This is R1 ಏನಂತ ಬಂದಿದ್ದಾರೆ. Notice issue to proposed ಅಲ್ಲ. Notice is awaited. ಯಾವಾಗ issue ಮಾಡಿದ್ದಾರೆ? Notice issued on 26th. Third. Registry shall verify the status of service of notice of IA 4-6 of 2023 and the proposed loss of deceased R1 on postal tracking. List on Vara Bitaka. Vara Bitaka and Vara Bitaka.
Number 3. Touch SPP.
ಮಾಡ್ಬಿಡ್ತಿದ್ರು postal track use ಮಾಡ್ತಾ ಇದ್ರು. Court awaited from first additional district judge Mandya. Section of NBW. What has happened? Execution against appellant accused. Time quoting the report about action taken against the sureties. Surety in arrestment. Surety in a bond forfeit ಮಾಡಿ recover ಮಾಡ್ಕೋಬೇಕು. Surety or accused. Forfeit ಮಾಡಿದ್ರೆ arrest ಕ್ಕೆ. That is incorrect alva. Where is that order? The papa surety ಆಗಿರೋದಿತ್ತು. First they have to recover it, then not recover then.
ನೀವು ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಅಂದ್ರೆ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರೋಪಿಯು ಪತ್ತೆ ಆಗಿರೋದಿಲ್ಲ. ಪತ್ತೆ ಆಗಿರೋದು ದಿವಸ ಏನೇನ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಎವ್ರಿಡೇ ಉಪಯುಕ್ತ ಮಾಹಿತಿ ಸಿಕ್ಕಿರೋದಿಲ್ಲ. ಅದರಿ ಜಯರಾಮ್ ಇದ್ದ ಶ್ಯೂರಿಟಿ ಜಾಮೀನುದಾರರಾದ 50 ವರ್ಷ ಅಂತೆ. ಅದೇ ದಿನ ಫಸ್ಟ್ ಎಡಿಷನ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಅಲ್ಲಿ ಅದಿದ್ರೆ ಬರೋ ಅಮೌಂಟು ಬರೋದಿಲ್ಲ ಅವ್ರ ಜೈಲಿಗೆ ಹೋದ್ರೆ. ಕರೆಕ್ಟ್, ಯುವರ್ ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್, ಯುವರ್ ಕೌಂಟರ್ ಪಾರ್ಟ್. ಬರೋ ದಿನಾಂಕ 3/10 ಕೂಡ ಅದನ್ನ ಅದಕ್ಕೆ ಕೂಡ ಪ್ರೊಸೀಡೆಡ್ ಅಗೇನ್ಸ್ಟ್ ದ ಪ್ರಾಪರ್ಟಿ. Don't know why, what order should we pass now? And it comes to our notice also now. Proceed against the properties ಅಂತ ಮಾಡಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ಇಟ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ಇದೆ ಅಲ್ಲ, ಅವ್ರು ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನಮ್ಗೆ ಬಂದಿಲ್ಲ. Why he was arrested? ಎಷ್ಟು ಜನ ಶ್ಯೂರಿಟಿ ಇದ್ರು? ಓನ್ಲಿ ಒನ್ ಶ್ಯೂರಿಟಿ. ನಿಮ್ಮವ್ರು ಯಾರು ಈಗ ಬಂದಿದಾರಲ್ಲ ತಗೊಂಡ್ ಹೋಗಂತ ಹೇಳ್ರಿ. ಅದು ಸಿ ಇಫ್ ಸಮಥಿಂಗ್ ಇಸ್ ಡಿಫಿಕಲ್ಟ್ these things happen. Police adhikshakar, ಅವ್ರದೇ ಬಂದಿದೆ ಅಲ್ಲ ರಿಪೋರ್ಟ್ ಬಂದಿ. He has not stated in the report that he has not received the warrant. Right? So we can't take cognizance of your submission. Submits the report of SP Mandya stating that the appellant accused is still untraceable. Is the offense ಏನು? He was the sole accused. And seeking time, extension of time to trace him. In the very report, it is submitted that the surety was arrested and produced before the trial court, and the trial court has remanded him to the judicial custody. The trial court should have forfeited the bond and recovered the bond amount. Surety to the judicial custody. Seek the report of the trial court regarding the same. ಅವ್ರಿಗೆ ಬಂದು ನಿಂತು ಬರೆಸ್ಕೊಂಡು ಹೋಗಂತ ಹೇಳ್ರಿ. ಹಾಗಾದ್ರೆ reissue and BW offense the appellant accused list on ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿದ್ರಲ್ಲ, ಯಾಕಂದ್ರೆ ವೆಕೇಶನ್ 30th ಅಕ್ಟೋಬರ್ ಅಲ್ಲಿ ತಗೊಂಡು ಹೋಗಂತ ಹೇಳ್ರಿ.
Mohammed Taqib, Prasanna Kumar.
ನನಗೆ ಬಂದಿರ್ಲಿಲ್ಲ, ಫೈನ್ ಹಾಕಿರ್ಲಿಲ್ಲ. What is the medical report? Yes. Regarding medical report of accused is received, placed below. The medical report. What is that report says? ನಿಮ್ಗೆ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ವಾ? Medical report of the appellant dated 31/7/2020. Maybe that. ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅದು ಯಾವತ್ತು 25 ನಮ್ಮ ರೆಕಾರ್ಡ್ ಇಷ್ಟು 25 ಅದು ಕೆಳಗಡೆ ಮಾಡಿದ್ದು. For ear surgery. There is no benefit on doing the ear surgery. This is for your information that was examined on 23/9/2011, presented with the history of hearing loss both ears following blunt injury to both ears. Both ear appear clinically. ಏನಿದೆ ಹೀಗೆ ಬರ್ದಿದ್ದಾರೆ, both ear appear clinically normal. DNA so physical, oral, neck normal, etc. Suggestive of bilateral severe mixed hearing loss. Hearing aid fitting for both ears. There is no benefit of doing ear surgery. ಅದು ಮಿಕ್ಸ್ಡ್ ಹಿಯರಿಂಗ್ ಲಾಸ್ ಅಂತ ಇದೆ, ಟೋಟಲ್ ಹಿಯರಿಂಗ್ ಲಾಸ್ ಅಲ್ಲ. as per the medical report submitted, medical report of St. John's Medical College Hospital. Medical report. The appellant has mixed hearing loss, and his ear appear clinically normal. It is further stated in the report that hearing aid fitting for both ears. Hearing aid, that hearing aid fitting for both ears, they suit him anta artha agutte. There is no benefit of on doing ear surgery. Even hearing aid and the hearing aid fitting for both ears means he is good with the hearing aids. There are so many advanced hearing aids now. You said he need immediate surgery last time. Now we refer the hospital suggested by you only. Counsel for the appellant seeks time to take instructions from the appellant. Please turn date. Next Monday. Friday. Yes. It's under complaint, sir. ನೀವು ಮಾತ್ರ ಒಂದೊಂದೇ ಸೆಟ್ ಕೊಡ್ತೀರಿ ನೋಡ್ರಿ. ಹೌ ಆರ್ ಯು ಪ್ರಿವಿಲೇಜ್? ಎಲ್ಲರೂ 2 ಸೆಟ್ ಕೊಡ್ಬೇಕು, ನೀವು ಮಾತ್ರ ಒಂದೇ ಸೆಟ್ ಕೊಡ್ತೀರಾ. ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್. Your office? ಅಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ಗೂ ಒಂದೇ ಕಾಪಿನಾ? Correct. You have not filed it in registry. When for the other parties we insist that you should submit. Now we registry and or correct why this discrimination anta. And xerox ಮಾಡಿಸ್ಕೊಂಡು ಬರಬೇಕಲ್ಲ. ಗುರ್ತು ಜಾರಿ ಮಾಡಲ್ಲ, ಸೈನ್ ಇರುತ್ತೆ. Who is respond number 2? Devi Ganesh, wife of Ganesh. Correct. She has signed on the notice. ಸ್ವೀಕರಿಸಿದೆ ನೋಡಿದ್ವಿ. ಎರಡು ಪೇಜ್ ಮೇಲೆ ಇದೆ. To submit report of the concerned police along with a copy of the notice. As we said report, respond number 2 is served. She is unrepresented. ಏನು ಮಾಡೋದೀಗ? ಬಂದಿಲ್ಲ ಅಲ್ಲ ಅವರು. When I was served 29/9/2023. Respond number 2 unrepresented. What is the stage now here? Limitation application pending ಇದೆಯಾ? ಲಿಸ್ಟ್ ಆನ್ ಒಂದೇ ಬಿಕಾಸ್ 29/9 ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದು ದಿವಸ ಇಟ್ ನೋಡೋಣ ಬರ್ತಾರೆ. There are 24 in the appeal memo corrected since appeal is out of time. Accused is sentenced. We have filed. Time word, there is delay of 9 days in filing the criminal appeal. All right, now we have filed. ಇದರಲ್ಲಿ ಏನಾರ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? the resistance places. IA2 of 2023 filed by the appellant for condonation of delay. Therefore, office objections do not survive for consideration. What is the offense? Not to 498. Okay. Now, got suspension also. What do you say for delay condonation? 9 days delay. They are in judicial custody. Only one case. 98 and 302. 12 years prior to the incident. Marriage was 12 years prior to the incident. This is filing this. ಫೋಟೋ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲಿ ಅರೆಸ್ಟ್ ಬಗ್ಗೆ ಏನು ಬರ್ದಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. Where do we find that the accused was in custody during trial or he was on bail? Your colleague is in charge. ಏನು ಹೇಳಿದ್ದೀರಾ ಈ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಅಥವಾ ಮೆಮೊರಂಡಮ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಅಲ್ಲಿ? Appellant is in judicial custody since 26 to 2020. Orders and A2 of 2023. Order accepting the explanation for delay of 9 days in filing the appeal is condemned in interest of justice. IA2 of 2023 is disposed of accordingly. Will admit and call for records then the matter requires full consultation. Admit call for TCRs. Paper book shall be prepared within 4 weeks from the date of the receipt of TCRs. IA1 of 2023 shall be heard on receipt of the TCRs. List after the receipt of TCRs. Seven office objections. How do you complete the course of the day? You'll have it on some other day. File ಆದ್ರೂ ಹೋಗ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ ಕಂಪ್ಲೈ ಮಾಡೋದು. At request 1 week time is granted to the government. The previous finally case times granted to find the failing which the appeal shall stand. 14/9 in the 2 weeks ಅವಾಗ ಆಗುತ್ತೆ 28/9 ಆಗುತ್ತೆ. When did you file the application? 5/9. Application 5/9 memo ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಆಯ್ತಲ್ಲ. ಯಾಕಂದ್ರೆ PCR ಇಲ್ಲ ಅಂತಾರಲ್ಲ ನೋಡಿದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ಸ್ ಫೈಲ್ ಕೊಟ್ಟು ಹೋಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಂದಿದೆ ಅಂತಲ್ಲ ಹೇಳ್ಕೊಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅಂತ ಇವಾಗ ಅವ್ರು ಏನು ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು ಆಮೇಲೆ ಹೋಗಿತ್ತು ಅಂತ ಬಂದಿದೆ. TCRs called on 16/9/2023. They are received kept below ಅಂತ ಮಾಡಿದಾರಲ್ಲ. KP ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅನ್ನೋದು KP ಅಂದ್ರೆ ತೀನ ಯಾವತ್ತದು 16/9 16/9 ಬಂದಿದೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ. See, you got the appeal dismissed already once. How long you want to prolong this? Your application is filed on 27/9. We had directed you to file it within 2 weeks. You should have filed this application within 2 weeks. Now the appeal, it was automatic. There was a peremptory order. Correct, if you file the application within 2 weeks, 28 27 ಗೆ ಆಗುತ್ತೆ correct. Not 20. But the record ಯಾವತ್ತು 39 ಗೆ ಬಂದಿದೆ. 16. ಕರ್ತದಿಲ್ಲ ಅಂತ ನಮ್ಮ ಮುಂದೆ ಬಂದಿಲ್ಲ. KP ಅಂತ ಏನೋ ಕರೆಕ್ಟ್ KP ಕಾಲ್ ಮಾಡ KP ನೀವೇ SMS ಲ್ಯಾಂಗ್ವೇಜ್ ಟೆಕ್ನಿಕಲ್ ಆಯ್ತು ಬಂದಿದೆ ಅಂತ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ ವಿಚಾರಿಸ್ತಾ ಇದ್ದಾರೆ. When it was dismissed earlier? Twenty-two 2009. Correct. Yeah. There was a peremptory order. He is saying that he could not do that because there were no TCRs. Have you any idea? ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ಅದು ಬಂದಿದ್ರೆ ನಾವ್ ಎಷ್ಟು ಟೈಮ್ ಕೊಡ್ಬೇಕು ಅಂತ ನೋಡ್ಕೊಡ್ತೀವಿ ಆಮೇಲೆ ವಿಲ್ ಪಾಸ್ that has to be taken along with the merits. We will see first whether records have come. Because you are the purchaser after the we'll think so. Restore andre it dates back to yes. I have filed application. That is correct. Okay. So you have filed memo for dismissal or withdrawal of the appeal? Dismissed on merit. Oh, this is a disposed matter.
We were contemplating finding execution. And they came forward with proposal to settle the matter.
5/1/2000. Yes.
Back in the settle between the parties, they want their money back, which was deposited from the court. Deposited this on the court. They have no objection to them.
Both appeals are dismissed. 5th January 2021. It was dismissed. You say you have no objection. It was, I mean, during granting state was amount was the time. Conditional order was passed.
I have admission in 2011.
This appeal is orders and I number 1/2023. This appeal is disposed of on merits on 5/1/2021. Now we have not filed execution also because of the settlement. The time of while granting in compliance of the order of granting interim stay, the appellant has deposited. Nam idu verification ಆಗಿ ಬಂದಿಲ್ವಾ ಅದು? You have mentioned 27,86,290. Correct. Registry ಅವರನ್ನು ನಮಗೆ ಸ್ವಲ್ಪ ನೋಡಿ ವೆರಿಫೈ ಮಾಡಿ ಹಾಕ್ಬೇಕು ಇದೆ deposited 27,86,290. Rupees 27,86,290. To come, the registry is not shown that. The same is invested in FD in Union Bank of India. The counsel for the respondent, the appellant is seeking withdrawal of the same. Lower counsel for withdrawal, release of the same. Lower counsel for respondent submits memo for Tata Coffee Limited. Stating that the respondent has no objection for release of the amount. The counsel for the appellant, the respondent submits that the parties have settled the matter after the. Oh. One submission now. Counsel for response submits that the parties have settled the matter after the judgment of this court. Considering the submissions, the appellant, the amount in deposit with accrued interest shall be released to the. Digitally ಅಂತ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. You have submitted that accounts particulars all yours. Then therefore the registration, the amount in deposit with accrued interest shall be released to the appellant digitally as paid for. I have to this person.
Number 10, Krishnappa Enna.
Application was filed after exemption application was filed. Attaining the reason he might be not there. Then he continuously remained after that person.
Thereafter.
Police arrested. Yes, they were
So you are pressing this application now? You want this application to be heard now or because matter?
I want to ascertain from that there are really documents to show that we are certain on subsidy. You may capital we are done. If they are not from
Adjourned at the request of the appellant's counsel.
Number 11, you are moving. Ask your question.
The order passed earlier on this Shoka service. No, in your synopsis, it appears you have not mentioned anything about the receiver. ಇದು ಬೇರೆನಾ? ನಾನು ಇದು ಬೇರೆ. 1/7. The submitted on which date? 11th April 2023 ಕೊಟ್ಟಿರೋದಾ? There are ಅಲ್ಲ ಇದು ಓದ್ಕೊಂಡಿದ್ದೀವಿ 11th April ಇದು ಕೂಡ 11th April 2020 ಇದರಲ್ಲಿ ಬರೀ citations. Yes, 17 This was on 18/11/2015. Showcase notice was issued, correct. Then what? He filed his reply. Okay. Therefore, Karadi, D.K. Rangegowda. He was the earlier receiver. This Vijay Kumar Karadi. The regarding direction of this court to issue notice to Vijay Kumar Karadi and D.K. Rangegowda shall be considered at appropriate time. So he submitted that this was not handed over to him. One of 2015 in this case. Yes. Read. Page. One day. I filed on 1st September 2015. So it is still pending. Otherwise, shall be considered at appropriate time and Tenamadita. Yes. Yes. H2 item number? No, second. Item number and tell page 2 is application. Application under order 40 rule. Affidavit. Yes.
And that they are claiming to have purchased the same. Appellant to pay the income and found that the entry showing sale of descent from the eminent Ranganathan represented by his GPA holder detail Diego. Now, position sale is dated
23/5/2011. He had died by that time. This Ranganathan is the testator, no? E. Ranganathan. But in 2011, he was no more. The 23/5/2011. No? This M1 14/8/2012. One second. M.N. Ranganathan is the same person who executed the will. M.N. Ranganathan, according to. Correct, but he was how the power of attorney survives. In this court. Dated 6/11 memo along with a memo. Yes.
I was appointed by the Honorable 29/7/2010. And both commissioner are having looking out the property. Property estimation. And then when you spend the house, you can also. Having the deed to get and waiting for the own property, you can not. I received a complaint from him and he not, and there is one. There is no on 9/4/2014. We have hired a year in 2015. Till then, nothing was reported by the other bank. In 2014. Then next paragraph. I requested Elvin Srinivas, respond number on the case to immediately lodge a police complaint. Next paragraph. My advice response number 1 was for second police complaint. On last paragraph, on my advice, what I'm trying to point out, there are several things in the content of the encoder. Try to turn to last page in there.
Correct. You were the court officer. You only could have filed the complaint. That position, you said you advised one of the parties to file the complaint. You were the court receiver. You only could have filed the complaint. One second. All right. Last but one paragraph of the report. Upaloka. Yes.
At my request and guidance, Elvin Srinivas responds at the required on 10/11/2014 and 2019. Trying to turn the case to
19, yes.
Yes. This coming according to case and this report is sent for first one. In earlier encoders 11, 12, 14, 15, and he says myself and the receiver, both are in protection of this one. All those are again
Who says that Srinivasan says him?
Srinivasan says, and the commissioner is reported that all are my address. And then I'm trying to take 57. Now, trying to turn to
It was commissioner or receiver? It was receiver. Yes.
57. That is enclosed on the 19th of this report.
Yes.
Page 59. In the middle paragraph, last 3 lines, he said
Hmm.
our students are continuing to be removed, is not being according to the commissioner, our advice, that is, and we are not having last 4 lines. That is, therefore, our students are continues to be removed. And he is in custody of the keys pertaining to also.
Flag and- Yes, and-
Okay, before I have also find it, my reply, that is also all that.
This memo, this 6/11/2015.
Yes.
Look back.
This one, I have it, 20 January.
ಹಿಂದೆ ಮುಂದೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. 2015 and 20th January 2016. Yes, got it. Hmm. 4 to 6. Hmm. Where are you reading?
Submission of complaint.
Huh.
He came to know from the Proceedings, he received that item was of. Illegally occupied by one state, really that we have. That as for excuse the advice, the first is not that by the representation to the honor. That's what it was a. It is pertinent to note that there is no complaint filed against who is said to have purchased this property by a registered state or the person who had admitted to experience. The enclosed number 90.
The matter was pending before the court. Why they went on writing to Upalokaik, etc. They could have made an application here only. Because it amounts to.
First of all, what is my role?
Adalla. See, when the case was dismissed. No, but this sale deed was executed during the pending of sale.
Because it's not due permission to me.
That will under counsel, that will consider, but you have said you advised the defendant to file a complaint, etc. He filed a complaint to the local. Why all that was required? You could have made the report to the court only about that. That's it. Correct. You exercise all the powers of the court.
Case was dismissed. My own-
Case was dismissed. Learned counsel. Case was dismissed subsequent to the sale. When the sale came to your notice,
The position was not-
why did you, even assuming that possession was not given to you, you say that you came to know about the sale, you directed one of the parties to file the complaint. You should have reported the same to the court instead of directing the parties to file a complaint or to Lokayukta. Where, to whose notice it should come first? To the notice of the court. If something happened to one of the property during the pendency of the case, right, that we'll consider, but why this activism, filing a complaint to Chief Minister, Chief Justice, Lokayukta, etc., without bringing it to the notice of the court? Yes. Yes. Court notice is first there. Exercise all powers of the court. ಎಲ್ಲ powers exercise ಮಾಡ್ತಾರೆ. ಈಗ suit ಇನ್ನು pending ಇರೋಲ್ಲ. And the more serious is, this is the power of attorney was here, he was no more by that time. Yes. Yes.
After the court is over, and the first point against the police, and the inspection of the court is. Prepared as per the receiver's was. The receiver and the together had information of the central. And together were looking on this.
Where are you reading? Together, class 5. Yes.
And for the leader.
Hmm.
Okay.
Sufficiency of the.
Prepared as the receiver's advice. The original stated in the same property is with the first and not with this. Next one, as per improvement made prepared as per the receiver's advice. We are to get continuous with the report. And he is in perspective of the piece pertaining to set out for. Okay.
Enclosure number 19 is the letter of that respond number, defend number 1. Right. You are referring to enclosure number 19. That is at page number 7. One second. Yeah. This was not his report. It was the report of the letter of that first defendant. No, is there any admission of the receiver? This is the statement of the first defendant. Memo. Okay. Last paragraph. This very memo, no? ಅಲ್ಲ ಈಗ ಯಾವ್ದು ಇದು ರೆಫರ್ ಮಾಡಿದ್ರೆ ಇದೆ ಮೆಮೋ dated 6/11/2015. 6/11/2015. 6/11/2015. This last but one paragraph. Page number. One minute. Page 5 ಅದ್ರೊಳಗೆ. Correct. ನೀವು ತೋರಿಸಿದ್ರಿ ಬಟ್ he says that defendant number 1 says that himself and the receiver were in possession. But in the mem-
He's not why. Commissioners are why. The receivers are why.
can we call it his admission?
Yes, he is the author. Again, I'm
Then
not trying to-
We can say that he was aware of it, but not taken, not resisted that, or did not say that he was not in possession. ಅದಕ್ಕೇನು reply ಕೊಡ್ಲಿಲ್ಲ ಅಂತ. Yes, accepted.
Who is he got possession ಗೊತ್ತಿಲ್ಲ.
All right. You, sorry for interruption. Yes, next continue. Your reply, no, your submission. Where are you referring? Hmm. There are two, just now you referred that, 5, class 5 you referred. Yes, yes. Yes, yes.
The following had one of the record that the first one document like there are 15 and 21. Again, written statement then the enclosures number 7, 11, 13 and 14. Here that you are looking of this for this right time and also the first one was appointed as to this one as per all date 24/3. Not by the on identity by allocated 17/1/2003. Passed by the fourth law on identity. The first one was removed from the receiver as it will to perform it with this asset. And the third operate for the fund the first one depends by the number 24 again to send order on identity. Then obtain care on 17/11/2003 the heading for this kind of observing the first one was unfit to be receiver. On 9/2/2004, the third operand business was transferred to a community report. To the lower court, finding out new business organizations and use of that done was process. On 20/6/2004, the subsequent filing the show cause moving for the benefits on the board as on 18/11/2015. Here by the report dated 6/11/2015. Along with it, that the possession of the property which was given to the recipient is not in possession. And Brahma this is that is linked to the character of the that is in the different services. Now in the different dated is to be shown as notice the receiver has stated as follows. That the possession of this property was not given to that the overflow is not for any order for a continuation for after this. And therefore he thought that his position and so the might have come to an end. Therefore he was unable to take any action. That therefore he directed not to respond to lodge a complaint. That he did not lodge a complaint to the police person as the land mafia has been made. And threatened him and he sending it by there are two of the described as the state. That it was the scientist advocate who handed over the case to the court and documents to the and not the earlier court. That no memo of instruction was given to him from the scientist. And he someone memo of instruction. That is the when the court commissioner will be memo. Not for the court receive. He has to give whatever instruction from the court. That's right. Given the and the copy of IM was not what the directions given by the court. In this law, it is the group of the following documents produce their own 1 to 5 perspectives. Here we establish that transferred in this year. Better date in 1910 now key there that the third was appointed to the present court receiver handing over the charge of execution to the acknowledged by the court receiver after items were duly verified by the commissioner of the letter number 23/9 was sent from the and it reply to the order. then at the particular of the thing by the to accept the delivery of the CD. The letter dated 27/11, so we can go on to receive. Okay, stating that the court has not given any direction, but it is the defendants who have given the memo. Memo dated 17/10, while the 1952, is from the above person. It is given to central to this. And this is the position. And not in a number.
Filed by you.
What is it?
1 second.
These things to work, and that is important, not appropriate.
Now, according to you, the property, somebody has sold the property, somebody. What would be the appropriate action?
And whoever is in custody of the property has to be. And also you have the report is to be.
That we ask, that is all. No. The next thing, because that purchaser is not a party here. Of course, if purchase is pending the suit, the court can direct to hand over the possession or to recover the possession. No, you said appropriate action. According to you, what is the appropriate?
Then the court will have taken given proper direction. And also, possible, court would have asked the police itself to hold an inquiry. Ultimately, not who are and whatever be the result. of
So
the-
before the trial court, it was not reported at all. This
Yes.
it was not reported. But they had accepted the receiver's position. You could have sought discharge.
In this case, what is my role of the degree is not.
Correct. See, the trial court, one second, trial court while passing the judgment did not discharge you. So you could have filed an application. All right, let the suit be dismissed. You could have sought your discharge. Court receiver means you cannot, it seems we are just
So you
seeking
mean-
clarification of our doubts. You are the court receiver. You are deemed to have the notice of all the proceedings which are going on. In the, you cannot say probably that, how can you say we were not aware? Because you are the officer of the court. When the court appointed you, during- not see a
Correct.
dismissal of a
Ask,
suit.
let us assume
According
that
to
it is-
your memo only, according to your submission only, you came to know about the sale pending the suit itself. Why did you not report it to the court? Why did, in your memo you have said, under counsel. One second. Memo, now we have given an admission that pending the suit, it was sold, it came to your knowledge, so you directed respond number 1, defend number 1 to file the complaint. That is your admission here in the memo filed by you, submissions filed by you. So it shows that pending the suit only you were aware that the property is sold to somebody under the guise of power of attorney who has no more. The principal. Allari, that complaint they have filed to the Lokayukta before, when the matter was pending before the trial court only. Ado, Lokayukta.
So then only the notice was. 3 years the file is not, I have infected there to file a complaint accordingly. In 2014.
Correct, one minute. Because all of you are the court officers. Suit dismissal. See, court receiver, can he say that I didn't have the notice of the dismissal of the suit?
Maybe know this case.
One minute. Yeah, can he say that he didn't have the notice of dismissal of the suit? All right, even thereafter. Even thereafter.
There is no stay also. There is no stay.
Say it, please, as the court officer, you tell us.
See, unless the court discharges a receiver, he continues to be a receiver.
Correct.
What else? Then we complain.
But he says on, one second. In his submissions, he says on his advice, you filed the complaint before the Lokayukta. right?
That's all the price.
Alright. We are lost to understand. If court officers, ಈ court ಅಲ್ಲಿ notice ಬಂದ್ಮೇಲೆ you should report it to the court. And you too, see, as a party, you too, because you too, this was subject matter of the suit, you also had claimed some interest in the property. ನೀವೇನ್ steps ತಗೊಂಡ್ರಿ ಅದನ್ನ recover ಮಾಡೋದಕ್ಕೆ could have asked, because it amounts to interfering with the course of justice by some parties. So why, what steps you should have reported, you should have filed an application for possession, seeking possession of the property, or for order of the court for possession of the property. What is it? You were complacent even if it was sold to somebody. You are not getting our point. Mr. Mohan. Why did you file it the complaint to Lokayukta, Chief Minister, etc. when the matter was sub judice? Matter was sub judice. Receiver is the officer of the court. Who should file the complaint? Why should you file the complaint? Correct, ನೀವು court ಮುಂದೆ ನೀವೇ ಬರ್ಬೋದಿತ್ತಲ್ಲ, ಅವ್ರು ಬಂದ ಹಾಗಿದೆ. Receiver has not done this ಅಂತ. There seems to be something amiss here.
See, when he directed you,
Both the document has been filed. By virtue of it, dated or whatever.
Who has forged?
It's only a investigation in the sense only can.
Allari, the matter was sub judice. You were a party to the proceedings. How could you file a complaint without bringing it to the notice of the court or without the permission of the court? It is continuation of the. It is a continuation. Mr. Mohan, stay irrilla andre this is the first appeal. It is the continuation of the suit only. List pendants are.
Possession of the receiver is equivalent to possession of the court. It is not the possession of the defendant number one. I think you, court commissioner, receiver, you misunderstood it. You should have informed to the court first. Why did you direct the defendant number one to file a complaint? You did not bring it to the notice of the court. Only when the court
Possession
asked
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ
you,
ಹೇಳಿದ್ರು.
then only you gave.
He
Yes,
said, no.
you should have asked
His
for the
excuse
possession
is
of
they
the
have
court.
not given possession. Did you report it to the court?
Court.
That that is ಅಲ್ಲ ಈಗ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಬಂದ್ಮೇಲಲ್ಲ ಅದಕ್ಕಿಂತ ಮೊದಲು.
See what is the layer? Advocate of the plaintiff has given me the decision way out. Party the receiver is not doing anything.
Correct. ನೀವು ರಿಸೀವರ್ ಆಗಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ court had directed you to take the possession of the properties and the movables. Correct. Did you? ಆಯ್ತು. They defied you because you are the court officer, as if you were stepping into the shoes of the court. Right? They did not do that. Did you report that pending the suit? That they have not given the possession of the. ಯಾವಾಗ trial court ಅಲ್ಲಿ ಎಲ್ಲಿ when that report was filed before the trial court? ಅಲ್ಲ ಎಲ್ಲಿದೆ ಹೇಳಿದ್ರೆ ನಾವು ರೆಕಾರ್ಡ್ ನೋಡ್ತೀವಿ. ನೋಡ್ಬೇಕಲ್ಲ ಬಿಕಾಸ್ ನಾವು ಎಸ್ ಅದ್ರ ಕಾಪಿನೂ ಹಾಕಿದೀರಾ ನೀವು? ಅಲ್ಲ ಅದ್ರ ಜೊತೆಗೆ ಅದೇ ಸಮ್ ಕಾಪೀಸ್ ಯು ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ವೆದರ್ ಇಟ್ ಇಸ್ ದೇರ್. ಅದು ಯಾವ ಕಾಪಿ ಅದು? ಬಿಕಾಸ್ he is saying he has submitted a report before the trial court itself. Where do we find that? 20th one? ಹಾಕಿರೋದು one second. Because there are multiple memos and 21/2016 ನಲ್ಲಿ page number ಯಾವುದು? Annexure 1. Okay. Received ಏನದು? Received the items mentioned from 1 to 19 along with 5 bunches of key by letter dated 19/8/2010 verified by plaintiff and defendant number 1 advocate. Advocate receiver ಅಂತ sign ಮಾಡಿದ್ದಾರೆ. He has said he has received the 5 bunches of key.
So you should,
Correct, ಹಾಗಾಯ್ತಲ್ಲ. If you are not aware of certain things, you had the duty to go and see because you had the very responsible. Then did you report that? See this, ಎಲ್ಲಿದೆ ಅದು ತೋರ್ಸು. ಇದು this was dated 19/8 to the date ಆದ್ರೂ ಹೇಳಿ ನಾವು ಹುಡುಕ್ತೀವಿ.
you should have the
Now
file.
you are
what you
assisted by
reported to the
defendant
court.
number one's counsel, at least you tell us. You are assisting him, you please tell us when he filed a objection before the trial court saying that he has not received. ನೀವಲ್ಲ ಅವರು. So you are, both of you are trying to.
What he did, you do not remember. What you did, he do not remember.
Suit was dismissed. Suit was dismissed. No order was passed discharging the receiver. He could have sought discharging of the receiver.
Receiver continues to be a receiver till he is discharged. Unlike the.
And very
court commission.
unfortunately, when the matter was
The role of
subjudiced,
commissioner is different
you
and
find
receiver.
some others above the court.
Not necessary.
Correct. ನಿಮಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ, ಅವ್ರು ಹೇಳುವಾಗ you were trying to assist him. That's what we said. Sir Mohan, see when receiver was one second. When receiver was submitting something, you intervened and you tried to assist him. That's why we asked you. Now, when the receiver was not discharged, it was the duty of the receiver to go before the court and seek the discharge. Otherwise, where these all things should be reported, the FD receipts and other things to be handed over, even if it is not discharged. It's very unfortunate. You were the Mr. Counsel, you were the court officer.
Receiver ಎಲ್ಲಿ key ಇಡಬೇಕು ಎಲ್ಲಿ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ you want to expect the court to give you the directions.
ಆಯ್ತು, correct.
Do you want that? Isn't it? No, not necessary. A receiver who is in possession of the property continues to be in possession of property even after disposal of the suit.
Even assuming that court ಮಾಡಲಿಲ್ಲ, ನೀವಾದ್ರೂ ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ. Orders are passed. I am possessing all these properties and these documents. Whom should I hand over? Please tell us in the court and ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ. It was your duty to ask that. You did not do that. You wanted to hold all those things because suit was dismissed.
Everything has been renewed and it was 24 lakhs and I received 74 lakhs after that.
Correct. But
But all property, I'm not aware of the.
For that also there was no order by the court.
Right?
For that also there was no order by the court for you.
ಅಲ್ಲ, ಈಗ if the some inadvertence, due to some inadvertence, the court had not passed any order, it was your duty to seek the instructions.
No. I can't accept that it was a mistake of the court. No.
Correct. For so many years thereafter, suit was dismissed in 2012. Alva? Suit was dismissed in which year? 2012. And up to 2015, it was not raised. And now you want to, even after the appeal was filed, you are aware that the appeal is filed. You are trying to blame the trial court all along. But after the filing of the appeal also, why did you not do that? ಅಂದ್ರೆ police stations are
Better than court.
police office. One second, Mr. Mohan, you are at bar and you have a long practice. Did you think that the police stations are above the courts? Above the high court, that too when the matter was pending in appeal. See, whatever, if something is done, if you atone that, then at least that could be considered. Otherwise, it may have to be viewed very seriously. If you keep So you earlier blamed the trial court, now you are blaming the High Court. Court deferred on that. Who had the moral and legal duty? Allah, Aito. Who had the moral and legal duty both? They have reported to the court. They have reported this to the court. Please, so your application is only to pass appropriate orders. Yes, please submit what. So you stand by that memo only. All right. What is your stand? Discharge ಮಾಡ್ಬೇಕಂದ್ರೆ ಅದನ್ನೆಲ್ಲ ಅಕೌಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. ಅಲ್ಲ ಆಯ್ತು. ಈಗ ಯಾರನ್ನಾರ ಲೇಮನ್ ರಿಸೀವರ್ ಅಂತ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಆಯ್ತು, ಫೀ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಇಫ್ ಇಟ್ ವಾಸ್ ಅ ಬರ್ಡನ್ ಆನ್ ಯು, ಅನ್ನೆಸೆಸರಿ ನೋಡ್ಕೋಬೇಕು ಅಂತಂದ್ರೆ ಯು ಕುಡ್ ಹ್ಯಾವ್ ಸಾಟ್ ದ ಡಿಸ್ಚಾರ್ಜ್ ಫ್ರಮ್ ದ ಕೇಸ್. ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ವಿತ್ ಯುವರ್ ರೆಗ್ಯುಲರ್ ವರ್ಕ್ ಗ್ರಾಟಿಸ್ ಇದನ್ನ ಯಾಕೆ ಮಾಡ್ಬೇಕು ಅಂತ ಅನ್ನೋದಿದ್ರೆ ಯು ಕುಡ್ ಹ್ಯಾವ್ ಸಾಟ್ ಯುವರ್ ಡಿಸ್ಚಾರ್ಜ್. It becomes little difficult now. One property, possession of one property is lost. This is regarding this matter. This is regarding this matter. But even assuming that their will goes, you were saying that in the will there is admission of this earlier will. If the will goes, that becomes non-existent. Then where do you stand? If that exhibit P11 goes, D1 is that? ಅಲ್ಲ ಇದು ಬಿಟ್ಬಿಡಿ, ಇದ್ರದ್ದು ಮುಗೀತು. No, the merits you had argued previously. Today this was only about receiver. When we went through the file, we found, suppose we accept your submission that their will was shrouded with suspicion and the suspicion was dispelled, their will goes. So far as your will, original was not produced, attested was not examined, right? You were
already I had done this not producing the original instance.
Correct, but you were trying to say that your will is admitted in the disputed will, their will. So even if original is not produced, that has to be accepted. Even if attester is not examined, that has to be accepted. Right? Now, if their will goes, that becomes non-existent. That admission does not remain there.
No. I mean, not only the admission in the will, it is the admission of legal to one also.
At section 57 or 58, admitted facts need not be proved. No, whether that applies to will.
That is what judgment which what is the base has been formed, saying that we are not in the custody of the original. We are producing the statement.
You called upon them to produce the original will? Yeah, it appears during last hearing that you argued that this was in possession of the testator. Testator died in their house, right?
Testator died in their house.
Right.
They have not said that, I mean, they are.
Allah, correct. That means that you are indirectly saying that it is in their possession.
ಅಲ್ಲ, indirect ಆಗಿ ಇದನ್ನ ನಾನು notice ಮಾಡಿ ಅಂತ ಹೇಳ ಕೃಷ್ಣ.
Order alone.
Literally, but ಹೇಳಿಲ್ಲ.
It appears ultimately, as he said, it goes by, it should go by succession.
It will not go. I mean, it will not go.
Only subject to this, because their conduct in this has to be seen. This item number 1.
Everything is relevant so far as I mean, doing the discharging the bonus from the Friday. That is what I have got to the list of people. And another is.
Which is the Supreme Court judgment you are saying?
My application.
Citation. Did you file any complaint saying that you are not in possession or lost it?
Application.
ನೀವು ಇಲ್ಲಿ ಹೇಳೋದಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. See, you say you are not in possession. In what way you are not possession? It did not come to your possession at all, or you lost it. What is that? I am not in possession. ಏನಂತ ಹೇಳಿದ್ರಿ? ಅಂದ್ರೆ testator gave you the Xerox copy. Correct. ಎಲ್ಲಿ ಇರೋ ಪಾಸಿಬಿಲಿಟಿ ಇದೆ will, where is the original will is likely to be ಅಂತ. You can't say ಅದು ನನಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ ಅಂತ. Last time it seems.
They said that you are in possession of the original will. And I mean, that application has been allowed, and we are allowed to certificate copy. And while
Mere production of certificate permitting you to produce.
asking the certificate copy to objection, they want to know last second.
Supreme Court has said that marking itself does not amount to proof. Even in any other case, more than.
Marking is not proving, I am not saying that. The Supreme Court issue money.
ಯಾವ್ದು ಹೇಳಿ, ಇನ್ನೊಂದ್ಸರಿ ನೋಡ್ತೀವಿ. ಅಲ್ಲ ಯಾವ್ದು ಹೇಳಿ, because you have given the bunch of judgments. You have given 9 judgments here. Which judgment deal with that? You all together did not leave that man to live peacefully. Anyway, either this way or that way. Yes, ಯಾವ್ದು judgment? Compendium ನಲ್ಲಿ ಕಂಪೈಲೇಷನ್ ನಲ್ಲಿ ಇಲ್ವಾ ಅದು? ಒಂದು ನಿಮಿಷ ನಮ್ ನೋಟ್ಸ್ ಅದ. Yes. What was the cause shown there for non-production of the original? Para 4 is about for declaration. Para 4 ಅಲ್ಲಿ facts. ಅಲ್ಲ, that foundation for non-production of the original, where is that? ಅಲ್ಲ, ಅದೆಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಬಗ್ಗೆ ಇದೆ. ಫೌಂಡೇಶನ್ ಫಾರ್ ನಾನ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ದ ಒರಿಜಿನಲ್ ಎಲ್ಲಿದೆ? ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇದೆ? ಪ್ಯಾರಾ 12 ನಾವು ಮಾತು ಮಾಡಿದ್ದೇವೆ. Arguments. It is also, that is argument. That is para 17 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಎಲ್ಲ ಅದಕ್ಕೆ ಇದಕ್ಕೆ
State ಅಲ್ಲಿ that was stated to be lost ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಇದು ಸರಿ, ಇಲ್ಲಿ ಬ್ಲಾಕ್ ಬಂದ್ರು
Cross examination regarding the loss of the will. ಈ ಕೇಸಲ್ಲಿ lost ಅಂತ ಇಲ್ಲ.
ಲಾಸ್ಟ್ 3 ಲೈನ್ಸ್
Para 12 ಅಲ್ಲ. Arguments ಅಲ್ಲ. Para 12.
It is also argued that the original is there and had not been produced, and no application for leading secondary evidence was found. Therefore, the secondary evidence could not be read by the defense to the execution. Now, kindly see para 14. The defense produced the certified copy of the legal of case from the office of discrimination. The defense also produced the photocopy of the legal scribed by the legal of the for 15. In a judgment reported in the MDP for only for instance, since this is another occurrence, then the occurrence that is filed a suit on the basis of a sale deed. During trial, the stand of the trial is that the original sale deed was lost. But since it was registered, secondary given by way of the original sale, the certificate of a prepared by the office of the registrar of the deed was not disputed that a copy produced was not the correct copy of the registered document.
ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ವಾ, ನೀವೇ ಒಂದು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ವಿಲ್ ಇವನ್ ಇಫ್ ಇಟ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್ ಅಂತ ಹೇಳಿ 1959 ಸುಪ್ರೀಂ ಕೋರ್ಟ್. In this case it was a sale deed, not will.
Sale deed ಮತ್ತೊಂದು ಕೇಸ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
They rely on this judgment.
It was not disputed that the copy produced was not the correct copy of the registered. The suit was dismissed for the reason that the client have not succeeded in satisfying the offense in the law of the requested. The court had it is no doubt not very likely that such a deed would be done, but in ordinary cases in the business in whose custody the deed should be put to its law, unless there is some motive suggested for it being unput. These evidence should be accepted as sufficient to get in secondary evidence of the deed. And if in addition, we were not cross-examined, this result would allow argument. There is no doubt that the deed was executed or it was registered and registered in a regular way. And it is the duty of the registrar before registering to examine the grantor or someone of whom he has satisfied his proper representative of the grantor before he allows the deed. Now, kindly come to the assembly. Even though they are for situation, in respect of the loss of sale, the state principle would be applicable in respect of in that.
So there the loss of sale deed was alleged.
Now, original moment is not the heritage. That is frustrated. I understand if I was running investment like it is, the party was with someone. It frustrated about it. There was.
Yes.
The present case says that the will was in possession of the building and was paid.
Citation related ಬರಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. Execution of a will was not disputed by the plaintiff. The will was the subject matter in the suit. This evidence of the suit that the original was lost and several copies for this. The defense are made sufficient. Ordinary course of beneficiary should have the original will. No, thank you for the company should hand over it to the beneficiary. And it only done the hell of that. ಇವ್ರು ಅಂದ್ಕೊಂಡಿದ್ದ ಏನಾದ್ರು ಪ್ರೂಫ್ ತೋರಿಸ್ತಾರೆ. ನಾವು their cases ಅವ್ರೇನು ಸೆಕೆಂಡರಿ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಫಸ್ಟ್ reason for non possession we have to prove it. ಈ ಕೇಸಲ್ಲಿ ಹ್ಯಾಡ್ ಲಾಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ಈ ಕೇಸ್ನಲ್ಲಿ ದಟ್ ವಾಸ್ ಇನ್ ದ ಪೊಸಿಷನ್ ಆಫ್ ದ ಟೆಸ್ಟೇಟರ್ ಹಿಮ್ಸೆಲ್ಫ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಲ್ಲಾದ್ರೂ ಒಂದು ರಿಸೈಟ್ ಅಲ್ಲ ಅವ್ನು ಡ್ಯೂರಿಂಗ್ ಲೈಫ್ ಟೈಮ್ನಲ್ಲಿ ಒರಿಜಿನಲ್ ಇವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳೋದು. ಈಗ ಯಾಕಂದ್ರೆ ಮಲ್ಟಿಪಲ್ ವಿಲ್ ಇರೋದ್ರಿಂದ ಇವೆಲ್ಲ ಇಶ್ಯೂ ಆಗಿದೆ. ಎವ್ರಿವನ್ ವಾಂಟ್ಸ್ ಟು ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ಅದರ್ ಪರ್ಸನ್ಸ್ ಡಿಫಾಲ್ಟ್. ನಮಗೇನು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕು, ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ಬೇಕು, ಅದನ್ನು ಮಾಡೋದಿಲ್ಲ ಅಂತ. ಶಿಕ್ಷಣ ಅಂದ್ರೆ ಇವ್ರು ನಾವೆಲ್ಲ ಪ್ರೂವ್ ಮಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಹೇಗೆ? ಯಾಕಂದ್ರೆ ಅದು ಅವಾಗ ದೇರ್ ಪೊಸಿಷನ್ ಅಂದ್ರೆ ಇನ್ ದೇರ್ ಕಸ್ಟಡಿ ಅನ್ನೋದು ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ. ಬ್ಲೆಮಿಷಸ್ ಅಂತ ಇಲ್ಲ ಇತ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಸರಿ, ಅದನ್ನ ನಾವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ದಟ್ ಕಂಟೆಂಟ್ ಕಮ್ಸ್. ಅದನ್ನ ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಇದು ಹೇಳಿದ್ರು ಇಟ್ಸ್ ಅ ಕೇಸ್ ಆಫ್ ಇಲ್ಲ. We have to read the evidence once again. ಯಾಕಂತಂದ್ರೆ ಅವ್ರು ಏನಾದ್ರು ವಿಲ್ ಬಗ್ಗೆ ಅಡ್ಮಿಷನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಯಾಕಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾವ್ ಸೆಂಡ್ ದಟ್ ದೇರ್ ವಿಲ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಂತ ಇವ್ರು ವಿಲ್ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅಂತ. Because section 68 compels that they should examine one of the attesting witnesses. You have not examined the attesting witness also. You have not examined the attesting witness also. Right? You examined some doctors.
ಮೊದಲಿನ ವಿಲ್
ಅಲ್ಲ 1992 will. 1992 will.
That attesting witness, one attesting witness has to be done.
Sufficient.
And you should be saying that as the other attesting witness here signed in terms of
presence.
ಅಲ್ಲ
some kind of sign.
document writer. Yes, Shashikant. Yes.
Indian Karnataka had this signature. Yes.
Yes, yes.
Indian Karnataka had put the signature of the original from the patent and the other in the presence of myself. And another attesting witness, we are not myself and are not the signature on both bills in the presence of each other and in the presence of the Indian Karnataka.
That examination ಮಾಡಿದ್ದೀನಿ. And the 25 witness volunteers that sufficient. When a person for plaintiff told him as to what is to be deposed with her was constituted on her. The witness volunteer said, Miss Chandra, Lama person for the plaintiff to be in the road in the ground. And so the Lama person for the plaintiff gave him instruction to depose with her was not know about mentioned M.N. Ranganatha. He says his evidence quality. I do not know the M.N. Ranganathan. Testator ನನ್ನ ಪರಿಚಯನೇ ಇರಲಿಲ್ಲ. ಪ್ಲೇಂಟಿಫ್ಸ್ ಕೌನ್ಸಿಲ್ ಏನು ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. That tester. I do not remember as to whether result of a sub-registrar. At the time of registration of the 2011, the deceased was suffering from ear ailment.
206 06.
Yes, ಅದನ್ನೇ ನೋಡಿದೆ. ಹಾಗಲ್ಲ, he says that the testator was the client of my uncle. ಅದಾಯ್ತು. I do not know above mentioned M.N. Ranganath. See, will is a very solemn document. He can ask somebody who in a term of, reposing confidence. Our we'll see. Okay. Hard.
Is it EWP? These are attesting or exhibit E. That is the. Case 271. Second. Villain number is another way attesting. Villain number is heavy rod
Rajgopal is another attesting. Allah, our pity, that is, you are now when we asked about your will or tester, you are trying to say.
My submission is only the certificate for which and any cross examination. And even in the evidence of
ಇದು ಇವತ್ತು ಇಲ್ಲ ಏನು ಕೋರ್ಟ್ ನಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಅದೇನೋ ಮೆಮೋ ಕೊಟ್ರಲ್ಲ ರಿಜಿಸ್ಟ್ರಿಯಿಂದ ಬಂದಿದೆ. ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ. The receiver, Shri R. Shiva Prasad, the receiver appointed by the trial court, present before court and submits for the amount heard the receiver and the counsel on both sides reserved. Those this thing you have submitted here, those FT receipts and other things. ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆ ಇನ್ನು. ಹಾಗಾದ್ರೆ until further orders you we pass an order that you should be in custody of this. Until since the trial court had not discharged the receiver, nor his receivery, nor you have not stated that in your memo. Order ಮಾಡುವಾಗಲೇ ಇದನ್ನ ಮಾಡ್ತೀವಿ.
Receiver, not.
First, nor the receiver sought the discharge of himself. The order for appointing the receiver continues. He should continue to hold the properties and documents in his possession till further orders. Or further result. We are not giving it. We reserve it for judgment. We are reserving it for judgment. ಅದರಲ್ಲಿ ಅವರು ಅಯ್ಯೇ further appropriate order to the receiver.
K. Prakash.
Yes, Prakash. Adjourned at the request of the response counsel. Yes. Yes. Adjourned.
Number 13, Zulfikar Kumar Shafi, SN Bhatt.
ಇದ್ರ ಕೇಸ್ ಅಲ್ಲ ಕಾಲ್ ಮಾಡಿದ್ವಲ್ಲ ಕಾಲ್ ಮಾಡಿದ್ವ ಇಬ್ರೇ ಇಲ್ವಾ ಅರ್ಜೆಂಟ್ ಓಕೆ
14 adjourned, number 50, Anand Rama case, plaintiff Somreti.
ಕೇಸ್ ಕರೆಸ್ದಾಗ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಲ್ಲ ಏನು ವಾಟ್ ಇಸ್ ಇಟ್ ಹೂ ಇಸ್ ದಟ್ ನ್ಯೂ ಅಡ್ವೊಕೇಟ್ ವಕಾಲತ್ ಹಾಕಿದಾರ ಅಲ್ಲಿ ಆಯ್ತು ಫೈಲ್ ಮಾಡಿಸಿ ನಾವು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಎಡ್ಜನ್ ಅಂತ ಅಷ್ಟೇ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಫೈಲ್ ಮಾಡಿಸಿ ವಕಾಲತ್
15 adjourned, number 50, Anand Rama case, plaintiff Somreti.
ಇದೇ ನಂಬರ್ 15 ಯಾರಿಲ್ಲ ನನ್ನ ಕೇಸ್ ಎಡ್ಜನ್ ಪ್ರೊಡಕ್ಷನ್ ಅವ್ರಿಗೆ ಈಗ ಈ ರಿಜಿಸ್ಟ್ರಿ ಇದ್ರ ಮುಂದೆ ಯಾಕೆ ಹಾಕ್ತಾರೆ ಇಲ್ಲ ನಮ್ಮ ಮತ್ತೆ ಹೇಳಿದ್ರು ಅಪೀಲ್ ಮೆಮೊ ಮುಂದೆ ಸ್ಕೆಚ್ ಮಾಡ್ತಾ ಹೋಗ್ತಾರೆ ವಕಾಲತ್ ಸರಿ ಹೇಳ್ಬೇಕು ಕರೆಸಿ ಈಗ ಇದು ಕೇಸ್ ಮುಗಿದ್ಮೇಲೆ you represent appellant ಅಲ್ವಾ this joint memo file Sixty 2021 ಅಲ್ಲಿ some joint memo was filed 14 lakhs
Two of them have executed the same. One of them does not execute the same. Right after a period of 10 months. Meaning that you have forfeited the, I am not interested in this. Upon what to pay the money and get the certificate. Such a reply. And again, after nearly 9 months, the suit. Now Supreme Court, Justice Indira Banerjee's judgment, Justice Readiness judgment. Readiness and willingness and the plaintiff who approaches the court for the suit. How to show that he had the necessary funds even during the continuation of the appeal.
the trial court has held that readiness and willingness document
The court says because who said these are of them buy the property in August 2004, nearly after 17 months. But he had the necessary funds. That is how they.
correct now you two do not dispute the execution of the agreement of sale what is the scope of this appeal appeal is only regarding execution of the sale deed
Execution.
scope is only that much
No, scope is now the execution of the sale deed. Plus, it is the appellant before the court only received 4 lakhs. The consideration was 50 lakhs. There is no division of the property. The trial court holds that possession has not been delivered because the appellant is still in possession of the property. And the fact that the sale deed is produced now with an application, the consideration that is shown is much less than what they had agreed. Fraud has been played. And the trial court says
was that the issue before the trial court
it was not, that was not the
no
issue.
fraud whether you had play
No,
please
I'm saying because the trial court comes to the conclusion that cash which is received by one of them has been received by the appellant also, which is not their own case. Take the
Correct.
court of the-
there will be 3 issues alwa one whether agreement of sale is admitted
Agreement of sale is not given.
Second one is whether he was ready to perform his part of contract.
Correct.
And consideration, whatever in
Main consideration that would arise is readiness.
readiness. That's what we're asking. So to proceed
I will
further.
take a part to trade. Because the whole world, electrical, still, a lot more.
I think they have produced the Xerox copy. Our type ಮಾಡಿ ಹಾಕಿದ್ರೆ ಮಿಸ್ಟೇಕ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. It is a Xerox copy of the plane. Now, sometimes what happens when our registry types, there will be some likelihood of some mistakes. ಆದ್ರೆ ಇಲ್ಲಿ ಅವರು Xerox ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ.
Even in spite of all this, there are a lot of mistakes.
If you say like that, you will be called outdated. My brother is a very techno-savvy.
You should decide now what is accurate. Unfortunately, that is not.
Precise, accurate.
The manual interventions will always result in these mistakes. Manually type ಮಾಡ್ತಾರಲ್ಲ ಅದು ಮಿಸ್ಟೇಕ್ ಗಳು ಹಾಗೆ ಆಗ್ತವೆ. ಎಕ್ಸ್ಪರ್ಟೈಸ್ ಇರಲ್ಲ, ಯಾವ್ದೋ ಟೈಪ್ ಇಟ್ಟು ಬರ್ತಾರೆ ಏನೋ.
ಅದೇ ಸರಿ ಇತ್ತು ಅಂತಾರೆ ಅವರು. ಕಂಪೇರ್ ಮಾಡ್ತಾರೆ.
ಅದನ್ನೇ ಪ್ರಾಬ್ಲಮ್ ಈಸ್
Check the draft and then again they would type. ಇವಾಗ ಏನಾಗುತ್ತೆ, they presume that it's on the computers and everything is correct. So there is no feeling at all at that.
ಅದು ನೋಡಲ್ಲ. ಅಂದ್ರೆ
ಕರೆಕ್ಟ್.
ಈಗ ಇಂಗ್ಲಿಷ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಗೊತ್ತಿದ್ದಂತ ಟೈಪಿಸ್ಟ್ ಗಳ ಸಂಖ್ಯೆ ಬಹಳ ಕಡಿಮೆ. ಅಲ್ಲಿರೋದು ಮಕ್ಕಿ ಇಲ್ಲಿ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ, ಅದ್ ಏನೇನೋ ಆಗಿರುತ್ತೆ. That is what is
This is one thing. Second, you were telling about precision. Precision ಆ ಕಾಲ ಹೋಗಿದೆ ಈಗ. ಈಗ ಲಾ ಕಾಲೇಜಲ್ಲಿ you have to write 2000 words, 4000 words. If you fail to write 2000 words, 4000 words, ನೋಡಿ ಈಗೆಲ್ಲ ಹೊಸ ಬಂದಿರೋ ಗ್ರಾಜುಯೇಟ್ಸ್ಗೆ ಗೊತ್ತಿರುತ್ತೆ. You will be failed. Whatever you write, ಅದನ್ನ what you have to fill that. 2000 words or 4000 words.
And now ChatGPT will come and they will write the essay from ChatGPT.
ಆ precision ಅನ್ನ
Even style of drafting. The voice from Chennai, you make the draft very, very small and simplified.
ಅದು ಹೋಗಿ
Whereas lawyers from Bombay, I think they are paid by the page. So it runs into several pages.
ಈಗ
The more you write, the more commitment you take, the more mistakes you make.
correct, but now the law college legal education what you had and we had was different. We were being told that precision shows your grasp and intellect, but now the days are changed. Law college fees are
This one-
Himalayan height, and they expect them to write in new ಹೊಸ graduates ತಾನೆ. Huh? Right. Oh, at that time, these filling the words 10,000, 5,000, 4,000 words, legal education was not there. Yes.
Again, there are subjects like white collar crime. More of white collar crimes, possibly that would make them more better.
Right.
equipped to deal with the
See, we do not know whether we are right or wrong. Ultimately, what if these white collar crime corporate litigations may be few, but common man's litigation, he wants to know what is his case, how it is dealt with, that's all. ಅದು ಇದೆಲ್ಲ, as you said, making it very elaborate, he will not get the point. Yes, please come to the point.
Natives of this one Narasimhan, son of the late Narasimha, the judge of India, along with the defendant in Krishna and another person in son of Venkappa, jointly purchased 1 acre 21 acres, including 2 acres of Kara, forming part of survey number 124. Mohammed Saleh, Mukhtaram, both sons of Mohammed Saleh, they exist under the same registered the document. So dated 7th March 1991, in the first roadshow in office, Nalman Karnataka. N. Murthy, one of the co-owners of said aforesaid property, sold his undivided share and interest in favor of Srimati H.S. Bharti, daughter of H.K. Siddhapura, under a sale deed dated July 16, 1990. The same was registered as document number 4. Plaintiff submits that the aforesaid property was therefore jointly owned and possessed by Narasimhaya, H.S. Bharati, and N. Krishna. N. Krishna is the appellant. Defendant herein, and each one of them had an undivided 1/3 share in the said property. Plaintiff submits that under an agreement dated March 6, 2003, H.S. Bharati, Narasimhaya, and the defendant N. Krishna agreed to sell their undivided interest in 1/21 guntas, including 2 guntas, forming part of survey number 112/1. Ashinikunte village, Kaspauli, Narmanda Taluk, Bangalore, Rural District, North, in particular is described in the schedule here and there. And herein after referred to as the schedule. The total sale consideration is 50 lakhs, out of which each one of the sharers is entitled to 16 lakhs 66,666.65, being the respective shares in the schedule. The plaintiff submits that the sum of money is 4 lakhs was paid to the defendant by means of the check bearing number so and so, and rupees 4 lakhs was paid to Narasimhaya by means of the check bearing number so and so. The check issued in favor of the defendant has been encashed and debited to the accounts of the plaintiff on March 13. Further sum of rupees 4 lakhs was paid in cash towards sale consideration jointly to all of them and received jointly by them. This is incorrect because he himself admits in cross-examination that 4 lakhs was paid to Narasimhaya and not.
So first 4 lakhs check was issued in the name of
Check was issued in favor of
dispute is with regard to cash.
cash. And the rest of the amount, which is all admitted in evidence, had been. All the 3 of them, including the defendant, agreed to receive the balance of sale consideration at the time of execution and registration of the sale deed in favor of the plaintiffs and or of their nominees in terms of the agreement executed by them in favor of the plaintiffs. Plaintiffs submit that one of the conditions of sale was that crime would not be essence of the contract, since certain formalities have been gone, that will be more time. It was further agreed that the portion of the shipping property be given to the plaintiffs within a fortnight thereafter. The sale was free from all encumbrances. It is submitted that the plaintiffs are in possession of the shipping property. Okay, that the agreement happened to the above. The trial court also holds that the plaintiff is not in possession. Plaintiff submits that at the time of agreement on March 6, 2003, all agreements have been used in the residential purpose. By an order of the deputy commissioner dated so in proceedings under so and a single put respectful and allotted Kata number in schedule property. After the agreement was entered into the landowners of the schedule property is converted from commercial use in proceedings under so Bangalore rural district. By order dated August 20, 2003, granted the permission for the court may notice the date of conversion. Because after August 2003, further formalities had to be completed. So the sale could have taken place immediately thereafter. The entire expenses of rupees 1 lakh so was met by the plaintiff, which is incorrect. That was also.
So agreement of sale was of 1992. Agreement of sale was of 1990.
Agreement of sale was in the year 2003, March 2003. 6 March 2003.
This conversion was in.
Unfortunately, what has happened here? In the first class, they say 6 months with the time that is given for the units. Next class, they say time is not the essence of the contract. Yes, strange drafting, but then that is the way it is. I have to go back. But then all the conversion also was done by August, which is within a period of 6 months. And the appellant before this one wrote a letter rescinding the agreement. There was no move on the part of the plaintiff, who is the respondent before this one, to say, I am ready and willing, please take the balance of the sale consideration and register the same deed. And the suit is filed in November 2000. Let me continue. The plaintiff submits that they were requesting the defendant to repeat the balance of sale consideration of 12 lakhs also. Rounded to the nearest. The plaintiff submit that they were likewise requesting Nasimaya and Excel Party to receive the balance of sale consideration and to execute the sale deed in respect of the rectified share in the property and to register the sale deed before the judicial registrar. Plaintiff submits that the defendant received the huge advance of rupees 4 lakhs from the plaintiff sale consideration of the undivided interest in scheduled property by means of check bearing the so this is a repetition. Thereafter, the defendant got a letter on February 6, 2004, 11 months later, sent through his advocate, P.M. Kumar, revoking the agreement to sell. Defendant got a letter. Defendant got a letter issued a printer. Defendant got a letter of the on receipt of the said letter, the plaintiff sent a reply dated February 14, 2004 to the defendant's advocate and also sent word to the other two co-owners that a sale deed had been prepared and had to be executed and registered on February 9, 2004. But because of the absence of the defendant, the plaintiff could not go to the sale. And we take the court to the notice and the reply. There is no such averment made by the plaintiff respondent. Subsequently, the plaintiff paid the amounts due to the other owners, Nasimaya and CH-5 party, in respect of their undivided interest in the scheduled property. The plaintiff submitted thereafter by a letter of March 8, 2004. The defendant got a reply sent to his counsel, enclosing a check bearing number so for rupees 4 lakhs and rescinded the contract between the plaintiffs and the defendant and refused to sell his 1/3 share in the scheduled property. Let me see, this is 5th March 2004. The suit came to be filed in November 2004. Why I am saying this is because the tax court judgment says immediate property prices of premium. This is less than 30-40 kilometers to time. Okay, the Supreme Court observes that you cannot wait, you cannot say a limitation is 3 years, I wait for 3 years and then file a suit for specific. More so when there is a refusal by the defendant to execute the sale. Thereafter, the plaintiff returned the aforesaid check to the defendant and demanded him to execute the sale deed in order to execute according to the agreement of March 6, 2003, and that they were always ready and willing to form their part of the contract, pay the balance of 2 lakhs and so on. It is submitted that the plaintiffs had spent a lot of money to obtain permission. Let's keep all this. The court holds that there is no proof to do all this. Next, paragraph 13. The plaintiff submits that they have been ready and willing to perform that part of the agreement with the defendant and the two co-owners, Nasimaya and Party. The plaintiffs got a sale deed drafted and finalized and informed all the 3 co-owners to receive the balance of sale consideration and execute a joint sale deed on June 28, 2004. And with that purpose in view, the plaintiffs informed the vendors of its defendant is one to execute the sale and to appear before the sub-registrar for the execution and registration of the sale deed in respect of the scheduled property. They submitted that only Nasimaya and H.S. Party, the 2 co-owners came to the sub-registrar office, but the defendant did not turn up in the closing of the case. The plaintiff and the other 2 vendors returned without executing the sale deed for want of participation of the defendant. All this is just, there is no proof for all this. The sale deed is executed in favor of the other two persons only in August 2004. Submitted that by a letter of August 2nd, 2004. The defendant was requested to receive the balance of the sale institution and to execute the sale deed along with the other two co-owners on 9 June, August 9, 2004, and to appear before the sub-registrar Nelmangala that day. But the defendant did not turn up in spite of the plaintiffs and the other co-owners, waiting for the defendant to execute and register the sale deed in respect of his undivided interest. It is submitted that a letter dated August 2nd, 2004 was sent to the defendant by registered post, also through courier and a postal certificate with the address given by the defendant to the plaintiff. But the letters sent by registered post and courier have not been claimed by the defendant, and the endorsement made by the postal authority showed that the growth was wrong. However, the notice sent and the postal certificate is deemed to have been received by him, since the same has not been returned so far to the plaintiff. ಎಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್ ಪೋಸ್ಟಿಂಗ್ ಅದಕ್ಕೇನು ಯಾರು ಇತ್ತು ಹೋಗಕ್ಕಾಗಲ್ಲ. So that does not mean that the appellant has been served with the said letter. The plaintiff submit that Nasimaya and HS party the agreement executed by them on March 6, 2015 jointly executed the sale deed with respect to the undivided two-third interest in the scheduled property in favor of the plaintiffs and their nominees. The sale deed was registered on August 30, 2004 and registered as document. So, he submitted that they sent another letter dated August 26, 2004 to the defendant and again requested him to receive the balance of the sale and execute the sale deed in favor of the plaintiffs of the nominees. The defendant was also informed that the other two co-owners, Nasimaya and HS Party, had executed a sale deed in favor of the plaintiffs in respect of their third undivided interest, and the details of the registration of the sale deed were also furnished to the defendant. He submitted that the said letter was sent to the defendant by registered post to courier and also the postal certificate the address given by the defendant. The letters sent by registered post to courier have not been claimed by them. However, the notice sent and the postal certificate is deemed to have been received by him, since the same has not been returned so far. Same story. The plaintiff submits that the defendant did not turn up to fulfill his part of the agreement, although the plaintiff would really their part of the agreement and to pay the balance of the sale consideration to the defendant and get a sale deed executed and registered in respect of the undivided one-third share of the defendant in the scheduled property. Then they tell a story about having met him. Plaintiff submitted after the execution and registration of the sale deed by Nasimaya and Srimati HS Bharati in respect of the two-third undivided share in the property. They met the defendant in his residence and also near the scheduled property. When he came there and requested him to accept the balance of sale consideration and to execute the sale deed in respect of divided share in favor of the plaintiff's third nominees, but the defendant failed to comply with his obligation under the contract and gave evasive replies. The plaintiff submits that having regard to the evasive conduct of the defendant, on November 10, 2004, the plaintiff sent copies of the notice dated August 6, 2004 to the address given by the defendant with the agreement to sell dated March 6, 2003 and also marked a copy of the said notice to the defendant's advocate, DM Kumar, to enable the defendant to execute the sale deed in respect of his undivided one-third share of the defendant in the scheduled property in favor of the plaintiffs. Copies of the said letter were sent both under the registered post and also under certificate of posting that it was here. If I had the money and my intention is to complete this case, and knowing fully well that the earlier letters have not been given. I would have made an effort to send it to the advocate who had sent the notice to. That has not been, which clearly shows that he did not have the funds to complete the sale with the other. Plaintiff submits that they also got public notice dated November 11, 2004, published in the issue of Vijay Karnataka in the issue of November 20, 2004. The plaintiff also sent a copy of the advertisement to the defendant to inform him about the publication of the defendant is aware of the advertisement as stated above. The plaintiff submits that the defendant has been evading and refusing to perform his job. That is to execute the sale deed in respect of undivided 1/3 interest in scheduled property. While the plaintiff is always been ready and willing to pay the balance and sale consideration in respect of the defendant's undivided share and get the sale deed registered in their name and in the names of their nominees. Unfortunately, what has happened? Use the language of the section. What is what we do? Ready and willing and it has to be proved. Just not enough bank accounts, food those Ide those Adela Madam. Very airport is ready and willing to go ahead and pay the balance of sale and have the sale executed. The plaintiff submits that it is agreed between the parties and that the agreement dated March 2003. In the event of the vendor failing to receive the balance of the sale price and execute the sale deed in accordance with this agreement, the purchaser shall be entitled to sue the vendors to take the balance of sale consideration to permit title in the scheduled property to the purchasers of the nominees. Likewise, if the purchaser should neglect to buy, the vendors enforce this agreement code to specifically perform. Apex code is held, there need not be a clause for specific performance. But if there is no clause, the agreement is specifically enforced. Anyway, these are no consequences. It is submitted that in terms of the agreement, the plaintiffs have always been ready and willing on their part of the contract and pay the balance of the sale consideration to the defendant. The plaintiffs have kept the balance amount payable to the defendant under the agreement separately and are willing to pay the same thing back. The plaintiffs are therefore instituted these proceedings to enforce their rights under the contract. It speaks specific performance of the agreement to sell in their favor and or their nominees in terms of the agreement executed by the defendant in respect of the undivided 1/3 share of the refusal by the defendant to sell his undivided share in the scheduled property has compelled them to institute these proceedings. Then, the cause of action to the suit arose on March 6, 2003. And the defendant, along with Nasimaya and H.S. Party, agreed to sell his undivided interest in the scheduled property in favor of the plaintiff. And when the defendant received 4 lakhs from the plaintiff towards the sale consideration, and as and when the plaintiff requested, was here. No mention is made of February 2004 when the defendant cancelled the agreement of sale and said, "I'm not willing to execute." That should have been made a plea, that should have found a place in the cause of action. And when the plaintiff requested, normally skip whatever is uncomfortable. That is the attitude of
Trick of the trade.
Welcome to that. He said you would never come to that because he had no answer to this. At the time. And the executor registered the sale deed of his undivided share in the scheduled property. And on November 11, 2004, he flatly refused, which is incorrect. February 2004 itself came. He didn't have to wait for a period of 9 months to file his suit, which is filed in November 2004. And within the suit is within time. The total sale consideration varies to. Then players are fiscally performed, receive the balance and skip those players. Kindly turn to the return statement. It's true that the defendant has jointly purchased 1 acre 21 buntas including 2,000 and skip this. Only the next same color, the last 5 lines. It is not correct to say.
Whether it
that-
was argued previously. Whether it was argued previously. There are some markings here.
Previously, the previous council had argued this matter before the. No, this was argued by Super Cash. Super Cash, and there was a compromise which my client, I mean, the appellant has not been given a consent. And I mean, some communication because they called and then it was.
There are some markings.
Yes, please.
There is a signatory to the compromise. Compromise petition ಅವರು sign ಮಾಡಿದ್ರಾ? ಬರೀ advocate signature. Correct. Why do you?
Later recall the
The
order.
order very clearly says in the unfortunate case where this court believes the statement made by the parties through their respective consequences. None of the parties was before the court.
Whatever may be the merits, but always safe for the bar members. It is safe that it should be done under the
Markings ಇತ್ತಲ್ಲ,
argument ಆಗಿದೆ ಹಿಂದೆ ಅನಿಸ್ತು ನಮ್ಗೆ. This matter was heard previously.
previous benches.
ಆಯ್ತು argumenting merits ಮೇಲೆ ಮಾಡಿ.
Submitted that even now the defendant Narasimhaya and Sripati HS party and parties are sharing this abroad. The contention of the plaintiffs that under an agreement dated 6/3/2002, Srimati HS party Narasimhaya and the defendant N. Krishna agreed to sell their undivided interest in 1 acre 24 plus described in the schedule is true and correct. Further contention that the sale consideration amount was 50 lakhs is also correct, out of which each one of the co-sharers was entitled to 60,66,000 and so on, being their respective shares in the scheduled property is not correct. Because there is no averment in the agreement of sale that the amount would be divided in 60. There is no such averment. The plaintiff in cross-examination admits that there was no division, there was no. The plaintiff paid his 4 lakhs to the defendant by check carrying in so and so. And both the checks dated 6/3/2003 drawn and the check issued in favor of the defendant has been debited to the account of the plaintiff is true and correct. The further contention that the sum of these 4 lakhs was paid in cash towards the sale consideration jointly to all of them and received jointly by them is true and correct. But in cross-examination, that agreement has been produced, only Narasimhaya receives the 4 lakhs. Then paragraph 4, it is submitted that it was further agreed that possession would be given within fortnight thereafter. According to this, the plaintiff possession was not claimed possession was not handed over to the plaintiff. It is false to state that the plaintiffs are in possession of pursuant to and under the agreement of sale referred to above. It is submitted that the conversion of the scheduled property was made by the defendant along with the other two owners. It is submitted that the agreement in para 8 so far as conversion of the scheduled property is concerned, but so far as the entire expense is was not met by the plaintiffs. In fact, the expenses over the conversion was met by this defendant and other co-owners of the scheduled property. It is submitted that the plaintiffs never asked the defendant to execute the sale after receiving the balance sale consideration of 12 lakhs and all. And the defendant does not know what transpired between the other co-owners of the property and the plaintiffs. It is submitted that the plaintiff and the other co-owners of the property and the plaintiff submitted in direct collusion with the other co-owners to defraud the interests of the defendant. The plaintiffs managed everything excluding the defendant to group him like paying extra amount to both the other co-owners before the sale date. All that is the fact which he admits in the proceedings. Leaving defendant all alone and in the other matters. It is submitted in this context. It is not out of place to mention with regard to the two other co-owners that the plaintiff number 2 Manish Gajaria, as in his reply notice dated 1/2004 to the notice dated 6/2, there must be a mistake with this. Like this. Regarding cancellation of the agreement dated 6/3/2003, as stated as your client has been paid rupees 4 lakhs, while Srimati H.S. Bharati is 9 lakhs, and Narsimhaya is paid 15,49,600. Towards the same consideration. That this reply given by the plaintiffs, number 2, that there is clear-cut collusion between plaintiffs and other two co-owners regarding the payment of advance sale consideration. Further, in the same reply notice, he has mentioned subsequently a sum of rupees 1,17,067 was paid to Narsimhaya, and no time is fixed for the completion of the sale transaction. It was here. Divide and rule. 3 ಜನ ಇದ್ದಾರೆ. ಇವರು ಒಬ್ಬರು ಬಿಟ್ಬಿಟ್ಟು ಇಂಥವ್ರು ಜಾಸ್ತಿ ಏನೋ ವ್ಯವಹಾರ ನಡೆಸ್ಬೇಕು. ಏನು ಇದೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಏನು. Because this man refused to execute the.
Is it your case that they were paid in excess of the amount agreed? Is it your case that they have paid to the others in excess of the agreed settlement?
That is not my case. My case is they have not produced the sale deed executed in August. If I take the court to the sale deed, register ಆಗಿರೋದು ಬರೀ 25 ಲಕ್ಷ ಇಬ್ಬರದು shares. It is not registered.
No, what was the total
Suppose 50 lakhs.
total sale consideration?
50 lakhs.
32 lakhs.
32
lakhs. So ಅದರಲ್ಲಿ ನೀವು ಹತ್ತತ್ರ 34 ಲಕ್ಷ 34 ಲಕ್ಷ ಸಿಕ್ಕಿದಾಗ 16 ಲಕ್ಷ
each of them. You will give 15 lakhs 49,600.
Order 41 road 27 ಜೊತೆ ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದ್ದಾರೆ. Just been allowed. ಆ ಸೇಲ್ ಡೀಡ್ ನೋಡಿದ್ರೆ it is shocking. It has been registered for 22 lakhs. 2/3 share. It should have been registered for 32 lakhs. 33, 34, 33 and what is registered? It is registered for some 22 lakhs. And that sale deed is also registered after a period of 15 months. I agree, limitation 15 years. But then I will take the court to judgment as read by Justice Indra Banerjee and even Justice Ravindra's judgment. There he says the appeal is also a continuation of the suit. The person who is entitled to special performance has to show that he has the necessary funds even today. Further, in the same reply notice, he has mentioned subsequently a sum of rupees 1,17,067 was paid to Nasimaya and no time is fixed for completion of the sale transaction. This also shows that plaintiff has got soft corner. I would say that's something else, but then I mean, with regard to amendments made in the claim, that also sent word to the other co-owners, Nasimaya and Bharti, to the defendant, that the sale deed has been prepared and has to be executed and registered on February 9, 2004. But due to the absence of the defendant, the plaintiffs could not go through the sale is completely denied as false. It is submitted that the plaintiffs have not sent any words regarding the applications of the draft sale deeds to the defendant to the other co-owners. It is submitted that the check for 4 lakhs was sent with the letter rescinding the agreement, and the defendant refused to execute the sale deed with regard to his 1/3 undivided share in the scheduled property in their favor. So it is true that the plaintiffs have sent back the check for 4 lakhs. So it is immaterial whether the plaintiffs accept the check for 4 lakhs or they send it back to the defendant. As of today, the contract for sale of scheduled property dated 6/3/2003 stands cancelled by the defendant, and there is no contract of sale surviving for the plaintiffs in respect of the undivided 1/3 share in the scheduled property. It is submitted that, as already stated in 5 of the written statement, plaintiffs have not spent any amount towards converting the scheduled land to non-agriculture. It is submitted that the defendant and the other two owners have spent for the conversion of land to non-agriculture. It is false that plaintiff has incurred other expenses towards improvement of the scheduled property, like leveling and making it into a viable place to develop the station. This the trial court also upholds and says there is no proof for all. It is submitted that the plaintiff's activities like erecting watchman shed, digging a borewell, obtaining the electricity, running are all false. It is submitted that the watchman shed that was constructed and electricity was obtained by the defendant and other owners for protecting the scheduled property. It is false that the plaintiff was ready and willing to perform their part of the contract right from the date of the execution of the sale agreement. It is further false to say that immediately after sale deed was drafted and finalized, this fact was informed to the defendant on 28/6/2004. It is submitted in the absence of the defendant and no occasion to go to sub-registrar's office. Then paragraph 13. It is submitted that so far letters sent by registered post and also clear to the defendant were returned to the plaintiff as though it was not. So far as letters sent to the postal certificate was not returned to the defendant, and thereby it is deemed that this letter was served on the defendant. In fact, the defendant has not received any letter dated 2/8/2004 from the plaintiffs. It is submitted that the defendant has no knowledge regarding the sale deed executed by the other co-owners in respect of the undivided 2/3 share in the property in question. It is submitted that the execution of the sale deed regarding the undivided 2/3 share of other co-owners is unknown to law. The possession of the lands without 1/3 share of the defendant is null and void. The joint possession of the suit land cannot be given by 2/3 shareholders, leaving the 1/3 share. As such, the whole transaction is null and void. This cannot be correct. I definitely will see. But then, property is not divided. Even possession is paper possession. Ultimately, were they plaintiff to succeed in the suit? Ultimately, even after this appeal, then it is open for them to regular possession. Dependent or the court will direct execution of this deed, not with them. Anyway, the trial court has held that he is not in possession. It is submitted that once the agreement of sale is cancelled, the question of executing sale deed and questions of that agreement does not arise. There is no point sending a letter on August 6, 2004, calling upon the defendant to execute the sale deed. The plaintiff has taken this contention to gain the sympathy of the court that they have sent a letter dated 26/8/2004, calling upon the defendant to execute the sale deed. Further, it is submitted that the said notice dated 26/8/2004 is issued by the plaintiff to arrest the defendant. Paragraph 17. It He submitted the defendant as suitably replied on 19/11/2004 to the notice dated 10/11/2004 that he was not bound to execute the sale deed in undivided one-third share. Had he had cancelled the agreement of sale dated 6/3/2003. As such, there is no evasive conduct from the part of the defendant.
What was the ground of cancellation? What was your ground of cancellation? He says
Saying
that
that I will take the court and go back and forth. I will take the court. Paragraph 21. It is submitted that the plaintiff's readiness and willingness to perform their part of the contract has no meaning at all into the contract so far as undivided one-third share is cancelled. Then paragraph 22. Just read from page 24. Hence, the contract to purchase the whole land of rupees 50 lakhs is not complied with, and as such, the sale deed executed by other co-owners is the result of collusion between the plaintiffs and the other two co-owners to defraud the interest and right of the defendant to use land. Hence, the agreement of sale dated 6/3/2003 was that the whole 1 acre and 21 guntahs of scheduled land was to be sold for rupees 50 lakhs is not carried out literally, and as such, the sale deed executed by the other two co-owners is not in accordance and in compliance with the agreement of sale dated 6/3/2003. As such, the sale deed executed by the other two co-owners does not bind the right title and interest in respect of defendant's undivided one-third share in the subsequent property. And these things were dismissed. And issues that were paid. Whether plaintiff claims that the defendants along with two others executed an agreement to sell the suit property. Each of the vendors have 1/3 right to the suit property, and they are entitled 1/3 of the said sale. The defendant has received 4 lakhs towards the sale consideration. The plaintiffs proved that they were always ready and willing to perform their part. The plaintiff further proved that actual possession in favor of the plaintiff, and they are in actual possession in the environment of the suit property from the date of the agreement. The plaintiff proved that the defendants are trying to eliminate the suit property and also trying to interfere in the possession and enjoyment of the suit property. The plaintiffs are entitled to sought what additional issues were stated. The defendants proved that the plaintiffs in collusion with other components to defraud the right and interest of the defendant. Plaintiff got executed the sale deed by the two co-owners, which is not in accordance with law. The defendant proves that two co-owners are necessary parties, and the suit is bad for one joinder of necessary parties. The defendant proves that the suit is not property bad. Court will pay this addition. The trial is essence. This suit is property value that paragraph 23 of the written statement. So he says court fee should have been paid on the entire 50 lakhs, not on 16 lakhs, 66,667. Then take the proof to the evidence. Then the judgment. Take the proof to the evidence. Page 75. Evidence. Then reading.
Late ಅಲ್ಲಿ ಇರೋ
ಕಾಪಿ ಮಾಡ್ತೀನಿ.
ಗ್ರಾಮೆಟಿಕಲ್ ಮಿಸ್ಟೇಕ್ಗಳು ಅಫಿಡವಿಟ್ ನಲ್ಲೇ ಸೇರ್ಕೊಂಡು.
You just copy and paste. PW2, you are reading PW2.
PW1 died. PW2 was.
He was partly cross-examined, PW1. Cross-examination. ಅವ್ರ ಶೇರ್ ಅವ್ರು ಮಾರಿದ್ರೆ ನಿಮಗೇನು ಕಷ್ಟ. Want to read that first?
I want to see.
You don't have the copy of that? ಇಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 90 ಅಲ್ಲಿ ಪಾರ್ಟಿ ಸವಾಲು ಪ್ರತಿವಾದಿಯ ಪರವಾಗಿ ಒಂದು ಪೇಜ್ ಪೂರ್ತಿ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಅದು. ಯಾಕಂದ್ರೆ he said he died subsequently. ಇದು ಕೊಡಿ ಬೇಕಂದ್ರೆ. You can see in this. ನಮ್ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ, ನಿಮ್ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ವಾ? ಕೊಡಿ ಇದು ನೋಡ್ಕೊಟ್ಟು ನಾವಿಬ್ರು ಒಂದ್ರಲ್ಲೇ ನೋಡ್ಕೊಟ್ಟು. ಒಂದು ಪೇಜು ಇಲ್ಲ ಅದು ಕ್ಲಾಸ್. Then a paper book alle they have made it one page. ಪಾರ್ಟಿ ಸವಾಲನ್ನು ಮುಂದೂಡಲಾಯಿತು ಅಂತ ಇದೆ. ಪ್ರಾಬಬ್ಲಿ he died there. ಯಾರ್ದು ನಿಮ್ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ನಮ್ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೇಜ್ ನಂಬರ್ 9. PW2 ಇಲ್ಲ. PW2 he was partly cross-examined. ನಾವು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರ ನಾವು ಸರ್. PW2 cross-examined. 1 second, we'll see. 102 PW2 recalled and duly summoned further cross-examination. Chief examination if possible court mistake ಇದ್ರೂ ಇರಬಹುದು ನೋಡಿ. ಕರೆಕ್ಟ್ 411 was chief partly examined 4/10/2008 ಗೆ chief examination conclude ಆಯ್ತು. 1 year after 1 year ಇದೆಯಾ?
ಅದು ಐ ಥಿಂಕ್ ಪೇಜ್ ನಂಬರ್ 102 ಮತ್ತು 104 ಅದು ಹಿಂದೆ ಮುಂದೆ ಆಗಿದೆ ಅಂತ ಕಾಣುತ್ತೆ.
23/1/2009
104 23/1 102 4/11.
Is it that he was cross-examined first? No, right. First he was cross-examined on 23/1/2009, or there was any other cross-examination? Because his examination in chief was concluded on 4/10/2008. 3 ತಿಂಗಳಾದ್ಮೇಲೆ ಫಸ್ಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್.
One page.
I take the first one.
Correct, he was first cross-examined on 23/1/2009. ಯಾವ್ದು ಇಲ್ಲ.
23/1/2009 is the first process.
ಹ್ಮ್.
ಅದೇ ಒಂದು ಭರತ್ ನನಗೆ ಮತ್ತೆ
ಹೊರಟಾಯ್ತು.
ನಮ್ಮ ತಂದೆಗೆ ನಾವು 5 ಜನ ಮಕ್ಕಳು. ಅವರ ಹೆಸರು ಮಾರ್ಬಿನ್ ಇಂಗ್ಲಿಷ್ ಓನ್ಸ್. ನನ್ನ ತಾಯಿ ಶ್ರೀಮತಿ ಸೋನ್ಸ್. ಅದೆಲ್ಲ ನಮ್ಮ ಕರಾರು ಮಾಡಿಕೊಂಡಂತ ಕ್ಷೇತ್ರ 1 ಎಕರೆ 21 ಗುಂಟೆ ಜಮೀನಿನ ನನಗೆ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 112/1 ಕ್ಷೇತ್ರ 1 ಎಕರೆ 21 ಗುಂಟೆ 3 ಜನರಿಗೆ ಸಮಾನವಾಗಿ ಭಾಗ ಇದೆ. ಈ ಆಸ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಮ್ಮ ಮತ್ತು ಪ್ರತಿವಾದಿ ನಡುವೆ ಒಂದೇ ಕರಾರು ಪತ್ರ ಆಗಿರುತ್ತದೆ. P2 ಕರಾರು ಪತ್ರದಲ್ಲಿರುವ ಎಲ್ಲಾ ಬರವಣಿಗೆ ಬಗ್ಗೆ ಆವಾಗ ಆಸ್ತಿ 1 ಎಕರೆ 21 ಗುಂಟೆ ಜಮೀನು ಖರೀದಿ ಮಾಡಲು ಆಸ್ತಿಯಾಗಿದೆ ರೂ 50 ಲಕ್ಷ ಅಂತ ನಿಗದಿ ಮಾಡಲಾಗಿತ್ತು. ಅದರ ಪೈಕಿ ತಲಾ 16 ಲಕ್ಷ ರೂಪಾಯಿ 3 ಜನ ಮಾಲೀಕರಿಗೆ ಒಪ್ಪಿಕೊಳ್ಳಬೇಕು ಅಂತ ಮಾತುಕತೆ ಆಗಿದೆ. ಈ ಪ್ರಕಾರ ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆಯಲಾಗಿದೆ. ಈಗ ತೋರಿಸಿದರೆ ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರ ನೋಡುತ್ತಿದ್ದೇವೆ. ಅದರಲ್ಲಿ 3 ಜನ ಮಾಲೀಕರಿಗೆ ತಲಾ 16 ಲಕ್ಷ ಹೋಗಬೇಕು ಅಂತ ಬರವಣಿಗೆ ಮಾಡಿಲ್ಲ. ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದ ಒಟ್ಟು ಮೊತ್ತ ರೂ 50 ಲಕ್ಷ ಆಗಿದ್ದರಿಂದ 3 ಜನರ undivided share comes to 1/3 share. As such, we have calculated the share of dependent Krishnappar at ₹16 lakhs. ನಮ್ಮ ಸಾಮಾನ್ಯ ತಿಳುವಳಿಕೆ ಜ್ಞಾನದಿಂದ ನಾನೇ ಪ್ರತಿವಾದಿ ಷೇರಿನ ಬಾಕಿಯು ರೂ 16 ಲಕ್ಷ ಅಂತ ಕಾಲದಲ್ಲಿ ತರಿಸಿದ್ದೇನೆ. ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರ ಆಗುವ ಕಾಲಕ್ಕೆ ನಮ್ಮ ಮತ್ತು ಪ್ರತಿವಾದಿ ನಡುವೆ ಕ್ರಯಪತ್ರ ಮಾಡಿಸಿಕೊಳ್ಳಲು ಅವಧಿ ನಿಗದಿ ಮಾಡಿರಲಿಲ್ಲ. ಏಕೆಂದರೆ ಅದು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಆಗಿತ್ತು. ಅದನ್ನು ಕಮರ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಕವರ್ ಕ್ರಾಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಹೀಗಾಗಿ ಅದಕ್ಕೆ ಬೇರೆ ಒಂದು ಆಸ್ತಿ ಮುಂದಕ್ಕೆ ಬೇರೆ ಒಂದಿತ್ತು. ಆಸ್ತಿ ಕಮರ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಮಾಡಿಕೊಳ್ಳಲು ನಮಗೆ ಒಪ್ಪಿಗೆ ಇದೆ ಅಂತ ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆದಿಲ್ಲ. ಅಂದು ಕರಾರು ಪತ್ರ ಆಗುವ ಕಾಲಕ್ಕೆ ಪ್ರತಿವಾದಿ ಮತ್ತು 2 ಜನರಿಗೆ ಸೇರಿಸಿ ಒಟ್ಟು ರೂ 12 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೇವೆ. ರೂ 4 ಲಕ್ಷ ನರಸಿಂಹ ಚೆಕ್ ಮೂಲಕ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇನ್ನೂ ರೂ 4 ಲಕ್ಷ ಹಣ ಪ್ರತಿವಾದಿ ಮತ್ತು ಉಳಿದ 2 ಜನ ಜಂಟಿಯಾಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ರೀತಿ 3 ಜನರಿಗೆ ಬೇರೆ ಬೇರೆಯಾಗಿ ರೂ 4 ಲಕ್ಷ ಹಣ ಕೊಟ್ಟಿದೆ. ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದಲ್ಲಿ ವಿವರವಾಗಿ ಬರೆದಿದ್ದಾರೋ ಎಂದು ನೆನಪಿಲ್ಲ. ಆದರೆ ಒಟ್ಟು ರೂ 12 ಲಕ್ಷ ಕೊಟ್ಟ ಬಗ್ಗೆ ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿ ಮತ್ತು ಉಳಿದ 2 ಜನರಿಗೆ ತಲಾ 4 ಲಕ್ಷ ಕೊಟ್ಟ ಬಗ್ಗೆ ಪ್ರತ್ಯೇಕವಾಗಿ ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆದಿಲ್ಲ ಅನ್ನೋದು ನೆನಪಿಲ್ಲ. Because he admits having this. ಕಮರ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಆದ ನಂತರ ಬಾಕಿ ಮೊತ್ತ ಕೊಟ್ಟು ಕ್ರಯಪತ್ರ ಬಳಸಿಕೊಳ್ಳಬೇಕು ಎಂದು ಮಾತುಕತೆ ಆಗಿತ್ತು. ಕಮರ್ಷಿಯಲ್ ಕನ್ವರ್ಷನ್ ಆದ ಮೇಲೆ ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಳ್ಳಬೇಕು ಎಂದು ನಿಶಾನೆ P2 ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆದಿಲ್ಲ. ಕರಾರು ಪತ್ರ ಆದ ತಿಂಗಳ 6 ಅವಧಿ ಒಳಗಾಗಿ ಬಾಕಿ ಮೊತ್ತ ಕೊಟ್ಟು ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಳ್ಳಬೇಕು ಅಂತ ವ್ಯವಹಾರ ಆಗಿತ್ತು ಎನ್ನುವುದು ನೆನಪಿಲ್ಲ. Then now I turn to page 100. It is true to suggest that in exhibit P2 is stated that the time limit for execution of the sale is 6 months from the date of the agreement. Witness volunteers that in the same agreement is stated that time is not recent. We have not issued any notice to the defendant during the period of 6 months for execution of the sale deed, expressing the readiness and willingness. Even after the period of 6 months, we will issue. It is not the plaintiff's case that we had issued. Even after the 6 months. It is true to suggest that he received a notice from the defendant dated 6/2/2004 as per exhibit P4. For that notice, we replied as per exhibit P5 dated 14/2/2004. It is true that in exhibit P4 2004, the defendant stated that the agreement of sale stands cancelled. It is true to suggest that I came to know on 6/2/2004 that the defendant is not ready and willing to execute the same deed. This portion may be very relevant because I point out the judgments of the apex court. It is true that we filed this suit in the year 2004, December. I did not intimate the defendant in writing to execute the same deed. It is true to suggest that in exhibit P2, the specific share of the vendors is not stated. But it is stated that they have got 1/3 share in the consideration state is different above mentioned. Expenses of commercial conversion are borne by us, but I have not produced the receipts to the effect. It is not true to suggest that the entire expense of commercial conversion was borne by the defendant. It is not true to suggest that the defendant has made improvement to the suit. I have no documents to show that I constructed the shed, compound, and got done the hotel in the suit. It is true to suggest that the defendant is not endorsed regarding the additional payments made on several dates. Plus, the other two, the signature is found of the other two co-owners, not this defendant at all. It is true to suggest that one Shivraj has received an amount of 30,000 on behalf of one Bharti, but no authorization letter was produced by the said Shivraj to the HSR. It is not true to suggest that a group endorsement of payments in exhibit P2. It is not true to suggest that ourselves have colluded together with Narasimha and HSR to defraud the defendant. It is not true to suggest that I am not entitled to anything.
What do you mean PW3? PW3 is the other purchase vendor. Other vendor. Hundred and ten.
After all, you support the case.
110.
But I will read it to them.
They were reading.
We
They
finished.
were reading because you were turning the pages.
we finished.
If you want to show anything in specifically, you can show that.
Suggestion of collusion, etc. Which has been denied. Not because. Now,
Yes, give them medium and answers to the questions.
cross examination. Okay. Is under
We'll continue in the afternoon. Then we will not be able to conclude. We are left with another 2 minutes. ಇಲ್ಲ ನಾವು we are not making parted. ಯಾವ್ದು ಮಾಡ್ತೀವೋ ಅದನ್ನ ಮುಗಿಸೋದು ನೆಕ್ಸ್ಟ್ ಹೋಗೋದು ಬಿಕಾಸ್ ದೇರ್ ನಿಮ್ಮದು ಮತ್ತೆ ಇನ್ನೊಂದು ಪಾರ್ಟೆಡ್ ಮಾಡೋದು ಬೇಡ. ಈಗ if we adjourn your matter, what is your difficulty in the afternoon? We have some personal inconvenience now. We now this roster is coming to the close. Half parted madre, he may brother may sit in some other bench. ಅದಕ್ಕೆ ನೋಡಿ ಈಗಾಗಲೇ ಮಾರ್ಕಿಂಗ್ ಮಾಡಿ ಒಂದ್ಸರಿ ಅಲ್ಲ, if you have some difficulty can come little later ನಿಮ್ಗೆ or it comes soon at 2:30 will come conclude and release it. Correct. How much time? How much time? You make some arrangement for your personal inconvenience today. You are taking half an hour. All right, we'll sit and conclude it now. Then come in.
I don't think I need to tell them.
That's why. Senior counsel, we always see it hurts us. 30 ವರ್ಷದ ಕೇಸ್ಗಳು ಪೆಂಡಿಂಗ್ ಇದಾವೆ ಅಂದ್ರೆ ಅವ್ರು ನಿಮ್ಮ ಮೇಲೂ ದೇ ಲೂಸ್ ಫೇತ್, ಗೋ ಆನ್ ಚೇಂಜಿಂಗ್ ಅಡ್ವೊಕೇಟ್ ಆಫ್ಟರ್ ಅಡ್ವೊಕೇಟ್, ಆಮೇಲೆ ಕೋರ್ಟ್ಸ್. ರೀಸೆಂಟ್ 43-year-old ಕೇಸ್ ಒಂದು ಮುಗಿತು. 43-year-old. How the litigants will sustain in those kinds of litigation? Partition, that was partition.
One party is interested in pursuing.
Correct, but we should not become we should not become parties to that.
I got it.
The previous case, hope you were there, that case, the receiver appointment case, ಕೇಳ್ತಾ ಇದ್ರ ಅದನ್ನ? Previously were present here, that receiver appointment. Maybe some adequacy on the part of the bar or bench, whatever it may be, but ultimately litigant suffers. We are aware that HRC
When you appear for a parent, you are paid to see that.
See that? It is delayed.
Never sees the light of the day.
ಅದಕ್ಕೆ ಏನಾಗುತ್ತೆ, the laws keep changing for that. Okay, afternoon we'll continue. So afternoon we are being told that Leonard Senior Counsel occupies good number of time. We are ready today. So ಉಳಿದವರು ಯಾರು ಬೇಕು ಅಂದ್ರೆ we can accommodate you.
Serial number 17, my lords.
Serial number 17. You are for the appellant.
Appellant.
Other side are ಇದು suit for specific performance.
ಕೆಂಪಣ್ಣ.
Oppose ಮಾಡ್ತಿದ್ರಾ last time?
ಇಲ್ಲ, I have been ready. I have not sought for adjournment in any previous date.
ನೀವು ಕೇಳಿಲ್ಲ, ನಾವು ಕೇಳಿದ್ವಿ, because in their actions to adjourn.
Anytime next week. It's
List on the date. What a vacation. 26. Serial number 23. Shankarappa ಅವ್ರದ್ದು. Rakshit Joyce is appointed as an custodian. We have to pay the cost to the amicus curiae. You can, because she or he is not, Rakshit Joyce is not here. Somebody is there on their behalf, Rakshit Joyce? Then we'll adjourn it and then at the request of Shri S. Shankapalana Council seeks permission to continue. The amicus curiae is not present. List after 1 week. R3, you are not appearing. That is first match 23 year R3 ಅವರು, he is SPP for R3 ಅಂತ ಇದೆ, not you. SPP for R3 ಅಂತ ಇದೆ ಶಂಕರಪ್ಪ ಅವ್ರನ್ನ ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ. ಶಂಕರಪ್ಪ is for R2. You have misread that. Hmm? 19 is already written. 21, huh? 20. You are for? No representation for the appellant. Okay. As requested, you want a particular date. You have sought injunction. You have sought injunction. Injunction for? Not to alienate, not to disturb possession. What is that? Not to disturb possessions. There was no injunction before the trial court. Permanent injunction. The permanent injunction is granted. Okay, why do you want us?
So therefore, it should be decided first.
As requested, the response counsel list on date. Alas, that then we'll, whether this application was ordered to be heard along with the main matter, no. Then I am hearing on the list madana. No representation for the appellant. As requested by counsel for respondents 1 and 2. This for the hearing on IA 1 and 2, 1 of 2023 on 10. ಅಂದ್ರೆ ಆರ್ಡರ್ ಸೆಲ್ ಬರುತ್ತೆ ಇಲ್ಲ ಅಂದ್ರೆ IA hearing. Orders. We have told our court officer only to inform us of you come here.
I'm here.
No. If you are not there, again we have to get stuck into another matter and again that will be parted.
I've been here all the way.
So, no, I had informed to inform us soon after you come. Why do you think that you are alone? So you are cautioning us also. Yes. Yes. One past story. No, you the advocates always have timeless mind, ageless body. ಅದು ಆಗೋದು ನಮಗಷ್ಟೇ. ಯಾರ್ದು ಒಂದು ಪಾಸ್ಟ್ ಓವರ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಯಾರ್ದು? ಏನೋ TCR ಬಂದಿದೆಯಾ? TCR ಬಂದಿಲ್ಲ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್. ಯಾಕೆ ಬಂದಿಲ್ಲ? Which is that court? Which is the trial court? From which place this is? ರಾಮನಗರ. ಇದೇನು ಅಷ್ಟು ದೂರ ಇಲ್ವಲ್ಲ? 16th ಕಳಿಸಿದ್ದಾರೆ. You have said the same reason here. Your application. What's the last one? What is the number 5%? Accepting the explanation for non-filing of the paper book. Time granted. How much time was granted? For filing the paper book is hereby extended by another 2 weeks from the date of the receipt of the TCRs. All right, from the date of the receipt of the TCRs. Registry shall issue reminder to the trial court. Issue and registry shall secure the trial court records and telephonic requisition forthwith. List after 2 weeks. 2 weeks after the receipt of the TCR. Allari, claim to idella nimma hatrane irutte. Pleadings. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೊಂದ್ಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು. ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಕ್ಕೆ ನಿಮಗೆ ಕಷ್ಟ ಅಲ್ಲ. unnecessarily, that is a old matter. 2009 matter. If such circumstance arise, you can file another application, right? Certified copy ಕೊಟ್ಟಿದ್ದು ನಮಗೆ ಗೊತ್ತಿರುತ್ತಲ್ಲ. ಇಲ್ಲ ಅದನ್ನು ಒಂದು ಬರ್ಕೊಂಡ್ಬಿಡಿ. Registry shall issue the certified required certified copies to the appellant's counsel soon after the receipt of the TCRs. If applied soon after the receipt of the TCR. Already applied, huh? Sir. Okay.
Cross-examination. Agreement, the agreement is stated time is not the essence. Next line, again it is stated that 6 months of so I will skip that. I will go to exhibit T2, page 136. The agreement is
Page 136.
6. Like in the first year of the agreement, the longer time, unfortunately, compared to the original records, this is what is just to be read. 136, 138, 140, 142.
136 is the Xerox copy of it.
What has happened here is behind each page there is an endorsement. Certain amounts are paid to the other vendors. So 136 and is 136.
Yes.
An agreement to sell 86 March 2003. Then page 138. I will skip page 138 also. 140. Vendors applied for conversion of the scheduled property for deputy commissioner for convert to non-residential for residential purpose. And the deputy commissioner was pleased to grant change of land use for residential purpose by its order. Thus, the vendors are collective owners and in peaceful enjoyment of the school. She said scheduled property, having got the same converted for residential purpose and formed the layout approved by the competent authority. Whereas due to need for liquid funds, the vendors are desirous of selling the scheduled property, and whereas the purchasers are offered to purchase the scheduled property, free from encumbrances for a lump sum consideration of ₹2 lakhs, and the vendors have accepted this offer as the same is the best price they can get for the scheduled property, having regard to the prevailing market value in respect of similarly situated lands, and in token thereof was received from purchasers in sum of ₹8 lakhs drawn on Canara Bank Lalbagh Road. And further, the vendors have received a sum of ₹4 lakhs by way of cash towards the sale price by way of advance, and agreed to receive the balance at the time of execution of the sale deed in favor of the purchasers of their nominees. Both the vendors and purchasers also wish to reduce the terms of the discussion agreement. Vendors will sell and will purchase the lump sum sale price of ₹50 lakhs. In consideration of the same, the vendors have received ₹8 lakhs by check clearing on the phone. And further, the vendors have received ₹4 lakhs by way of cash by way of advance, and they agreed to receive the balance at the time of execution of the sale within 6 months from the date hereof. Here it says 6 months. Time is not the essence of the contract. Formalities of the law. It is taking shelter under this, but I will point out that their own document shows that even this formality is over within a period of 7 months. The date of taking. Vendors have agreed to hand over possession of the scheduled property purchaser of their nominees within a fortnight. This is not happening. The vendors will not enter into an agreement or agreement to sell with anybody else or encumber the scheduled property in manner so long as this agreement is in force and binding. The vendors are scheduled to be the vendors will execute the deed of conveyance and all other assignments and all other assurances in favor of the purchaser or their nominees given at the price. The cost of preparation of the sale deed, registration charges, and all other expenses shall be borne by the purchasers or their nominees. In the event of the vendor failing to receive the balance of the sale price and execute the sale deed in accordance with this agreement, the purchaser shall be entitled to the vendor to take the balance of the disposition and convey rightly to the scheduled property purchasers or their nominees. Likewise, if the purchaser should neglect to buy the vendors may enforce the schedule. Then the schedule. Kindly now turn to 137. In the first page of the agreement, there is an endorsement. Which is signed only by Nasimaya. That on this day, 16 July 2003, the vendors have received from the purchasers so and so ₹6 lakhs entered by us with the purchasers on 6th day of March 2003. Thus, the total advance so far received is ₹18 lakhs. Calendar note agreement.
Correct, the
The
payment.
payment of vendors to N. Krishna is pending. The Narasimha signature is there. Now please turn to 139. This is only in order to demonstrate that all, actually it is said all is fair in love and war. It is not fair. How you both them you have colluded with the other two vendors. Kindly see page 139. That this 14th day of August, we the vendors have received from the purchasers further sum amount of ₹2 lakhs towards the considerations for the agreement. Thus, the total advance so far received is 20 lakhs. This again only Narasimha's signature is And there is no dispute, this payment made to vendor Sri Narasimhaya only.
They have not suppressed it. They have said that it is paid only to Narasimhan.
Correct. Then when you enter into an agreement, end the agreement to do an adjustment.
No,
And there are three vendors.
correct. Each of them were entitled to 16 lakhs and out.
No, that is not mentioned. That is not mentioned anywhere in the agreement.
Hmm.
Neither the division of the property is mentioned nor the amount is mentioned.
No, is it whether they are, no, whether they were denying, whether they denied that you are not entitled to 16 lakhs and out?
They will deny. Saying, when you do a collective agreement, it is trust will be there if all the parties execute even the further endorsement. In order to show that without the knowledge of the appellate, all this has been done under consent. And kindly see page 141. At this date of September 2000, the vendors have received in purchases Srimati so and so rupees 2 lakhs by way of check so and so drawn on Canada Bank. This also is signed, payment is made to vendor Sri Narasimhaya only. Over the signature. Then page 143. At this, the 24th day of May 2004, I have received the sum of rupees 30,000 from Sri so and so. This is signed by one Shukla on behalf of CH-5. Then kindly see exhibit P3. In the agreement.
But
of
she
sale-
does not dispute this.
Beg your pardon.
She does not dispute the authorization. That may not be
Now they
very,
have executed the sale deed. Why is
correct,
it
that may not be.
The
Where
allegation-
we read the saying that this Shivraj this authorization letter was not yet.
Pointing all this out in order to show what has been the content of the.
You are trying to say
And
that
the other two vendors.
they have discriminated you against the others on the head of others.
Discreetly, all this has been done. At least see exhibit P3. Plaintiff only produces. Adhikruta Jana. Japana Patna.
Should be DC's office.
This is a conversion order. The agreement was entered in March 2003, 6th March. There is a clause that
This was dated 6/10/2003. Commercial.
but it is evidence he says industrial conversion ಆಗಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ time was not the essence. So he himself produces a document that within 7 months from the date of the agreement, even this conversion was granted. There was no impediment for him to offer the balance of sale consideration and have the sale deed executed in their favor. Plaintiff did not have any impediment. Then exhibit P4 at page 147. 6/2/2004. This is read by the appellant stroke defendant. This legal notice. You are aware that on 6/3/2003, you have been entered into an agreement with the client and other two others, namely just Bharti and Sri Narasimhaya to purchase also described in the schedule to this notice for a sum of rupees 50 lakhs. Though this time stipulated in the agreement for completion of sale transaction was 6 months, from the date of agreement, you have not bothered to get the sale transaction completed within the stipulated time. Thereby, you have lost the right to call upon the vendors, including my client, to sell the scheduled land to you. As such, the agreement dated 6/3/2003 becomes unenforceable. Apart from this, now my client has come to know that you are conspiring with other vendors to dupe my client and deprive him of his right to receive the remaining balance certification due to him being a joint owner of scheduled property. As such, my client is no more interested in containing his promise to sell the scheduled property to you jointly, along with the other two vendors. Therefore, my client has revoked the agreement of sale entered with you jointly along with two others so far as the further change in scheduled property is concerned. My client will return his share of advance of lakhs received from you under the agreement dated 6/3/2003. Now the reply is at page 148, the back of this page. But it's a reply to council. It's true that an agreement of 6/3/2003, your clients and two others agreed to sell the land to my father and me for a total consideration of ₹50 lakhs. The share of each owner being ₹66,66,667. The possession of the property has been given to you. Your client has been paid ₹4 lakhs, while Srimati H.S. Bharti is paid ₹9 lakhs, and Mr. Narsimhaya is paid 15,49,600 towards the sale consideration. So, reply is sent on. This is also after a period of 11 months. And this is after 4 months after the conversion was granted. And 6 months had been specified in one clause, plus the other one said time is not the essence, because certain formalities had been. What was the formality? Conversion was done as early as now. Now, these two vendors had received most of their consideration by the time February. Whereas even now, and read the rest of the notice and then the submit. Initially, the land had been converted for residential purpose, and it was later converted for commercial purpose, and we admits that it has been converted. That is the document of October 2003. But under Chala number so and so, conversion is also granted by order number so and so. You kindly turn back to page 146, 145. ಐದನೇದು ಭೂಪರಿಧಿಯ ವ್ಯತ್ಯಾಸದ ಶುಲ್ಕ 1,60,534 ಮಾಡಿರುವುದು ಇವರು. ನರಸಿಂಹಯ್ಯ ಅವರು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಸಲ್ಲಿಸುವ ಅರ್ಜಿ ಅವರಿಂದ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆಯ ವ್ಯತ್ಯಾಸದ ಶುಲ್ಕ 1,60,534 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. Who remitted that? ಅಲ್ಲ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಬಟ್ ಆಕ್ಚುಲಿ ರೆಮಿಟೆನ್ಸ್ ಕರೆಕ್ಟ್. ಈಗ when you have to pay somebody something, the other person may go and pay.
Court also says that no document has been produced. I will take the court to all the documents.
They have not produced any material to prove they had remitted. So,
now I continue with this. Para 3 of page 148. Initially, the land had been converted for residential use, and it was later converted for commercial purposes. And we have paid ₹1,60,534 towards conversion charges and Chala number so and so. Conversion is also permitted by order number so and so. Your client is aware that the sale deeds have been prepared and were to be registered on February 9, 2004. But the other co-owners informed us that your client was not available on that day. This is a self-serving state. But there is no proof. He admits that he has not done any technique. Subsequently, a sum of ₹1,17,067 was paid to Mr. Narasimhaya. 15,49,000 ಅಂದ್ರೆ 1,17,000 ಕೊಟ್ಟಿದ್ದಾರೆ. He has received the full consideration. Even if it is presumed that each is entitled to 1666, he has received the full, Narasimhaya has received the full consideration. Mr. Narasimhaya, no time, however, we have made huge advances towards the agreement. And we are still ready and willing to have the deeds registered as soon as my father returns. Here again, time is up. Your client is aware of all these facts and is claiming that the agreement of March 6, 2003 has become unenforceable is not correct. The imputation that we have been conspiring with the other two partners to dupe your client and depriving him of his rights to receive the balance consideration has no basis whatsoever. And he is putting forward lame excuse to resign from the ground and to revoke the agreement if possible. If possible. Your client has no justification to back out of the deal after having used advances. And your client is bound to receive the balance and execute the same deal along with others. Likely not able to cooperate at this. Okay, nearly 11 months old. The plaintiff should have tendered the balance amount and said, I am giving this amount to you. Please come and execute the same. That is also. Then the defendant appellant sends a rejoinder. That is at page 683/2004. In continuation of notice dated 6/2004 sent on behalf of
Page number?
the
I'm sorry. Page?
Page 150.
Yes. Yes. Yes.
In continuation of notice dated 6/2004 sent on behalf of my client N. Krishna, I herewith refunding the advance amount of rupees 4 lakhs received by my client on 6/3/2003 towards part of his share in the sale consideration, since he does not intend to join hands with other joint owners in executing the sale deed in respect of property agreed to be sold, in executing the sale deed in the favor. I hope you would acknowledge the receipt of this check. My client reiterates that he has rescinded the contract dated 6/3/2000, entered into with you on 6/3/2000, along with two others joint owners to sell his 1/3 share in the school. Same person, immediately after the February notice itself, the file is. But he does not choose. Why I am saying that is the apex code says Osuna land spread Jasi at 30-40 kilometers from time. So time is the time you should see that you execute the sale deed immediately. You can't say 3 years before the period. This Arshin Kunte is 28 kilometers from time. 22 kilometers from time. Now, I don't know how these documents could have been marked. Exhibit 378. They are unsigned documents. It should have been created for the purpose of the case. Not signed by anybody. There is no proof that such a
No,
document.
is it a typed copy or
It's in the type copy.
correct? Then draft sale deed,
Draft. Consider it.
draft sale.
Consider it. Absolute sale deed.
Well, if absolute and there, is it according to them draft sale deed or it is executed by other two persons? No, it's draft sale. Draft. Correct, while marking whether you had objected it. While marking whether that was objected on any ground.
page of this evidence. At page 120. So the court will have to look into the admissibility of such a law. Yes. Basically, paragraph 13 is what is the explanation of. I submit that my son and I have always been ready and willing to perform all part of the executive. We got a salary drafted and bills and informed all the three owners to receive the balance of the sentence and execute the joint salary as per exhibit P6 and P7 and on June 28, 2004. And with that purpose in view, the plaintiff informed the vendor of which the defendant is one to execute the sale deed and document. Such a document has been said. They should have been the letter with the acknowledgement of the defendant. We were not defendant. At least the other two vendors. Adu illa very personal. It's available. Both unsigned documents have been
There are signatures. In exhibit P8. Exhibit P8.
time of writing should have considered and looked at this. That has not been.
P7 is relevant only if some acknowledgement, postal acknowledgement is there. In the absence of that,
No, but since it has been marked and just
marking,
marking is a ministerial act. Then exhibit P9. It's sent by plaintiff. Even in the evidence, he is not able to show that this has been served. upon
Marking is not just a ministerial act. Marking is not just a ministerial act.
That is what the
Court-
court said.
No, 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 no.
Yes, the-
But the courts have to apply their.
The document was admissible or inadmissible at the time of hearing.
It's not like that.
Anyway,
Later, a judgment came that too in criminal cases. Justice Thomas, earlier that used to be, objections used to be raised, objections were to be decided then only. On that order, there used to be revisions or appeals. So to avoid that, what was held, even Justice Ravindran Sahib on judgment today.
marking for the purpose of identity.
No, except in the cases of stamp and another ಇನ್ನೊಂದು ಎರಡು ಕೇಸಲ್ಲಿ ಮಾತ್ರ ಅದು they have to be decided then and there only. Other cases that has to be marked noting the objection and the objection shall be decided at the end of the hearing of the case ಅಂತ ಇದೆ.
I think P7 is signed by P7 is signed by two other vendors.
Original ಅಲ್ಲಿ
It is on
P8
the-
ಕಾಪಿ P8 ಅಲ್ಲಿ ಕಾಪಿ
P7
ನಮ್ಮ ಪೇಪರ್ ಬುಕ್ ರೆಡಿ ಮಾಡಿ ಹಾಕವ್ರು ಅದನ್ನ ಮಾಡಿಲ್ಲ.
P7 ನಲ್ಲೂ ಇದೆ.
What they have done is P8 they have xeroxed the document and put it in the paper book. But P7 they have typed it seems. ಅದರಲ್ಲಿ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅವರು. ಕರೆಕ್ಟ್ ನಮ್ಮ ಪೇಪರ್ ಬುಕ್ ಎಲ್ಲ that we can say. See, it is one. Only probably he is like us. He is listed by this paper book. In the original record, brother is showing that there are signatures of 2 other vendors.
78 ಎರಡಕ್ಕೆ
ಎರಡು ಸರಿ ಕಳಿಸಿದ್ರು ಅಂತ
ಎರಡು ಒಂದೇ ಡೇಟ್.
No. Was being asked why 2 drafts sealed it.
Same. ಯಾಕೆಂತ
ಸ್ಟಾಂಪ್ಸ್ ಜಾಸ್ತಿ ಇತ್ತು ಅಂತಾರೆ.
28 June, 28 June. 28 June. Both are 28 June.
Really moves and history.
June. ಆಮೇಲಿಂದ ಇನ್ನೊಂದು draft ಕೊಡ್ತಾರೆ.
ಒಂದು ಸ್ಟಾಂಪ್ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಇನ್ನೊಂದು ಎರಡು ಸಂದರ್ಭಗಳಲ್ಲಿ ಮಾತ್ರ
ಅಲ್ಲ ಅದು ಒಂದು ಐ ಥಿಂಕ್ one is for 39 guntas and another is 20 guntas.
ಅನ್ಡಿವೈಡೆಡ್ ಶೇರ್ ಅಂತ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಬೇರೆ 39 ಗುಂಟಸ್
ಎರಡು ಬೇರೆ ಇದೆ.
2 ಪ್ರಾಪರ್ಟೀಸ್ ವರ್ ಪರ್ಚೇಸ್ ಓನ್ಲಿ 1 ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್.
ಒಂದು ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದೆ.
ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಎಷ್ಟು?
112/1. 112/1 ಎರಡು 112/1 ಬಟ್ ಅದು ಒಂದೊಳಗೆ 20 ಗುಂಟ ಇದೆ, ಒಂದಲ್ಲಿ 39 ಗುಂಟ ಇದೆ.
2/1 means 1 acre 21
ಡ್ರಾಫ್ಟ್.
No, why you there was difference between all that you can proceed now.
ಅಲ್ಲ ಪರ್ಚೇಸರ್ಸ್ ಬೇರೆ ಇದ್ದಾರೆ. ಮನೀಶ್ ಗಜರಿಯ ಒಂದು, ಗಿರೀಶ್ ಗಜರಿಯ ಒಂದು, ಇನ್ನೊಂದರಲ್ಲಿ ಭರತ್ ಗಜರಿಯ, ಮಾಧವಿ ದೂದ್ವಾಲ. ಅದನ್ನೇ ನಾಮಿನಿ ಪರ್ಚೇಸರ್ಸ್ ಬೇರೆ.
Provided in agreement, purchasers are
Their nominee. Anyway, you are on the point of readiness and willingness. Your submission that is noted. The delivery of the same is not proved.
One is readiness.
Regarding these 2 documents, we are saying that your point that the proof of delivery of these documents. That
The legal notice. We have sent a letter. August 2nd. That also no proof of delivery. He himself advised. The registered post came back exhibit P9 at page 160. The registered post came back. Even the courier was not delivered. It is only the certificate of posting which didn't come back. So he says it has been delivered.
so it was returned as not claimed. P9.
Exhibit P9 at page 160.
Somebody's signature is there. P9.
P9 at page
9A. Sorry, P9A. P9A is a postal acknowledgement.
Correct. Only the receipt, the acknowledgement is not there.
Not insured.
And he admits that registered post we have not received.
This is
It has
post-
not been delivered.
Postal certificate. The certificate of posting is 9B. Certificate of posting is 9B. Certificate P9A is
receipt.
receipt for having sent it by RPA. Acknowledgement. Yes.
My before we pass that, he admits that the acknowledgement, only certificate is not returned, so we presume
Yeah.
that he is
Not claimed under.
not claimed that for the data.
That is exhibit P10. page number 172.
Again, exhibition 14 is 191. Another letter alleged to have been sent, even this has not been served. Admitted to this. Your
Is they related to each other or what is this vendors? Are it senior counsel?
yeah, no.
They were not related, separate.
Strangers joining today's. So I purchase a problem. This is what happens.
Strangers entered into. These developers agreements will be like that only. Or ಅಕ್ಕಪಕ್ಕ ಇದ್ದವ್ರನ್ನೆಲ್ಲ ಸೇರಿಸಿ. Probably
ಅಲ್ಲ,
these
ಈ 3 ಜನ ತಾವು ಡೆವಲಪ್ ಮಾಡ್ತೀವಿ ಅಂತ ತಗೊಂಡ್ರು,
ತಗೊಂಡಿರ್ತಾರೆ.
ಕೈ ಸುಟ್ಕೊಂಡ್ರು, ಬೇರೆಯವರಿಗೆ ತಗಲಾಕಿ ಇವ್ರು ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ನಿಮ್ಮಲ್ಲಿ ಒಬ್ರು
probably these people also
ಮಾಡೋದಿಲ್ಲ.
purchase with an intention to develop the property.
How together they purchased it?
Later explain.
ಅಂದ್ರೆ ಅವ್ರು ಯಾರೋ 3 ಜನರ ಕಡೆಯಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು ಅಂತ ಬಂತು. ಮೂರ್ತಿ ಟು ಭಾರತಿ, ಭಾರತಿ ಟು ಕೀರ್ತಿ ಆಗಿದೆ ಈಗೆಲ್ಲ. Yes.
Exhibit P17 and page 197. November 10, 2004. Just read this. This is sent to the defendant. August 26, 2004. We had sent you a letter requesting you to execute the sale deed in favor of your undivided share in the properties. So in terms of agreement to sell executed jointly by you and Lakshmaya and Bharat. After going through the files, I realized that the letter has been sent to another address given by you and returned by the postal authorities has not claimed. Now the truth is out. However, the letter sent to you and the certificate of posting has not been returned. I therefore presume that you have received the signature.
So it was not
Explain what is that.
agreement of sale ಅಲ್ಲಿ ಇದ್ದ ಅಡ್ರೆಸ್ ಕಳಿಸಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಬೇರೆ address ಇದೆ. ಅವ್ರೇ ಒಪ್ಕೊತಾನೆ.
ಅಲ್ಲ, ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಅವ್ರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
Correct. He says it was given to another address furnished by. This is 232 second of third stage Vishweshwarman.
There is no acknowledgement that it has, you have seen that said there.
Agreement of sale is at page number.
Page number.
P7 is ended. P2 ಅಲ್ಲ, agreement of sale is executed.
Agreement of sale. That is at page 136.
136. What is the address? Vishnu. 232 third stage second block Basveshwar Nagar, Bangalore.
Now this letter is sent to the correct
Second
address.
block third stage Basveshwar Nagar, Bangalore.
Send to another address. Our
Earlier letter is addressed to which
address, that is address to some other.
page number. ಅದು 22 second stage third block Basveshwar Nagar.
232 ಅಲ್ಲ, 20.
Yes.
You possibly do a step forward and say, the address was wrongly shown to the because he did not have the receipt. Though no cross examination is there, and requesting the court to draw an inference. That was why
So what is the cross examination of PW1, PW2 with reference to this readiness and willingness or availability of funds? ನೀವು ಅವರನ್ನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ
ಅಲ್ಲ ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿ
ನೀವೇನು whether you have made a suggestion that
yes if the written statement I read out even in
Right.
the cross
Cross
examination
examine. Just to refresh our memory, what was it? We didn't.
it is for a person who approaches the
Correct.
court.
That is correct.
who
You
is
are right.
Initially,
Initially, he has to show that
cross-examination
he was ready and willing. Yes.
ಅಲ್ಲ, ಬರೀ ಬಾಯಲ್ಲಿ ready and willing ಅಂದ್ರೆ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. And point out from the judgment. So
Affordability.
to produce documents, evidence to show that.
Cross examination. ಓದಿದ್ರಿ ನೀವು? ಅಲ್ಲ, ಏನು?
Page 102, he says it is good to suggest that exhibit P2 is stated that the time of limit for execution of the same thing is 6 months. Witness volunteers, then we have not issued any notice to the defendant during the period of 6 months for execution of sale deed, expressing readiness and willingness. It is true that to suggest that we received a notice from the defendant dated 6/2/2004. As per exhibit P4, for that notice we replied as per exhibit P5. It is true that in exhibit P4, the defendant stated that the agreement of sale stands cancelled. It is true to suggest that I came to want 6/2 that the defendant is not ready and willing to execute the sale deed. It is true that we filed this in the year December 2004. I did not intimate the defendant in writing to execute the sale deed. I pointed out even from the reply to exhibit P4, he does not tender the money. That would be readiness and willingness, not just saying in the following the language of the section and say, I am ready and willing to pay the balance sale consideration. And to the court in BC page 105. Cross examination. I am reading this for my benefit. I pointed out the document of conversion. That is October 2003, 6/10/2003. Now he himself admits in cross examination, commercial conversion ಆದ ನಂತರ ಬಾಕಿ ಮೊತ್ತ ಕೊಟ್ಟು ಕ್ರಯ ಪತ್ರ ಬರೆಸಿಕೊಳ್ಳಬೇಕು ಅಂತ ಮಾತುಕತೆ ಆಗಿತ್ತು. ಅಂದ್ರೆ ಕನ್ವರ್ಷನ್ ಆಗಿದ್ದು 6/10/2003. ಪತ್ರ 6 ತಿಂಗಳ 6 ಅವಧಿ ಒಳಗಾಗಿ ಬಾಕಿ ಮೊತ್ತ ಕೊಟ್ಟು ಕ್ರಯ ಪತ್ರ ಮಾಡಿಸಿಕೊಳ್ಳಬೇಕು ವ್ಯವಹಾರ ಆಗಿತ್ತು ಎನ್ನುವುದು ನೆನಪಿಲ್ಲ.
Week 13. Absolute sale date is 13th August 2000.
ಅಲ್ಲ 181.
181 exhibit P13 ಅಂತ ಹೇಳಿ. ಅದೇ ಕರೆಕ್ಟ್.
Whether in the bank or they produced a certificate copy of the same.
Okay. Or is it a? Is it again a dark salary or absolute salary? It's a salary itself. What is it? It's original.
When we turn to page 183, well, you turn on page 4 of the same. Page 4 of the same. Last question. Since the scheduled property was abutting the main road, the property seemed to be not very conducive for residential purpose. Hence, the vendors applied to the Bangalore Rural Deputy Commissioner for converting the said land now from residential to commercial use. Bangalore Rural Deputy Commissioner was pleased to grant them the conversion by his order number so dated 6th October 2003. They again referred to that. After collecting the due amount of additional conversion fees of rupees 1,60,534 and subsequently from residential to commercial use, the vendors approached the concerned Gram Panchayat for appropriate changes in the use of the scheduled property. The Ashinakunte Gram Panchayat was pleased to grant them single karta bearing K number 651. Thus, the scheduled property is duly converted for commercial purpose and is in peaceful and possession of vendors, and they have paid all the taxes and municipal outgoings in respect of the same to the competent authorities, including Ashinakunte Gram Panchayat. It was here. It's not to be said. Though the agreement says 6 months, the sale had to be completed. Then they say that time is not the essence because certain formalities have to be. What is the formality? Conversion to commercial. That was done as early as 6/10/2003. So nothing prevented them, nothing prevented the plaintiff from tendering the amount and having the sale deed executed in incident. Even after the defendant refused to execute the sale deed and rescinded the contract because of the plaintiff not having performed his part of the contract, the plaintiff files a suit only after a period of 9 months from the date of the sale. Kindly see later in the sale deed. Whereas the vendors along with the Krishna so that I skip that paragraph. The next two paragraphs, the next paragraph, whereas the vendors were in need of money, meet their domestic and other demands, and to purchase some other property which are beneficial to them, the vendors are desirous of selling their third undivided interest in the for a total valuable sale consideration of 14,99,200. The sale consideration should have been not 14,99,200, but it should have been 33 lakhs and
33 lakhs on that if you had also joined. 32 lakhs if you had also joined. No,
Beneficial enjoyment goes on.
Ah.
That's what is.
the value, it is an undivided
Now
share.
it's fragmented.
Now it comes down.
Specific.
Correct. ಇವತ್ತು 3 ಜನ ಸೇರ್ ಕೊಟ್ರೆ
Specific.
ಆಯ್ತು, ಅನ್ಡಿವೈಡೆಡ್ ಶೇರ್ ಕೊಟ್ರೆ ಅದರಲ್ಲಿ ವ್ಯಾಲ್ಯೂ ಕಡಿಮೆ ಆಗೇ ಆಗುತ್ತೆ.
What brother is trying to say is, if the property, entire property was given, that is not stated.
ನಿಮಗೆ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ನಿಮಗೆ ಬರಬೇಕು ಅಂತ ಆಯ್ತು ಸ್ಟಾರ್ಟ್ ಬೇಕಾಗಿತ್ತಲ್ಲ.
No, for this person, no, for this one thing they have not said that specifically. Secondly, for this
ಅಲ್ಲ
person,
14 ಲಕ್ಷ ಅಷ್ಟೇ 15 ಲಕ್ಷ ಆಗಿದ್ರೆ ಈ 35 ಲಕ್ಷದಲ್ಲಿ 4 ಲಕ್ಷ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ 31 ಲಕ್ಷಕ್ಕೆ ನೀವು
ಹಾಗೆ ಹೆಚ್ಚಿನ ಇವ್ರು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು. ಈಗ entire property was agreed to be purchased. Now, since one person did not join, their utility reduces. They will not.
What they explain? You
No,
can't reduce
no,
by so much.
That is
Allah, in order to show that there has been pollution and it is not fair. So far as the defendant is concerned, readiness and willingness was not there to tender the amount, nor he has asked him to execute the sale deed.
ಅವ್ರು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ
Whereas he said safe line being the maximum the vendors to get for the second.
because they one more thing
And
they
with
say,
regard to the market value.
Yes.
Estimate of sale at market value.
guideline value of the property is 22,48,800 and the value of the undivided interest of the vendors is 14,99,200.
ಇಲ್ಲಿ 25 ಲಕ್ಷ ಆಗ್ತದೆ value. No, I asked myself this question. Looking at this, it doesn't give any confidence to you. It is not fair.
the question is, see, if the entire property was sold, the value of the property was 50 lakhs. Now, 2/3 share is undivided share is given. Okay. Now you have cancelled the your agreement. Now they have to file a suit for 2/3 partition. Now there will be, you will be fighting tooth and nail. And it will prolong for another 10 years. And that is why the value has come down.
Disadvantage.
That is what I am saying.
To some disadvantage, probably rate might have been reduced on the.
And it
But
is
that is here.
between them 14 lakh or 1 rupee, what matters? It doesn't matter to you.
Let me accept this also, but then kindly see how the payments are made.
Correct. That in pursuant to your agreement, that payment, etc., yes, that holds good.
Allah, ಹಿಂದೆ sale deed ಅನ್ನು ಮಾಡ್ತಾನೆ. ಅವನು first second
ಅದೇ ಹೇಳಿದ್ದಾರೆ.
next in pursuance of the said agreement and in keeping the guidelines value of the property in rupees 22,48,800 and the value of the undivided interest of the vendors in the scheduled property is 14,99,200. Same is Allah, may I pause here? Such an argument has to be advanced.
We are not yet heard. We are only allowed to give.
ನರಸಿಂಹ ಇಷ್ಟ ಒಪ್ಕೊಳ್ಳಿಲ್ಲ ಅದಕ್ಕೆ ಪ್ರಾಪರ್ಟಿ ಕಮ್ಮಿ ಆಗಬೇಕು ಆದ್ರಿಂದ 25 ಲಕ್ಷ ಮಾಡ್ತಾ ಇದ್ದೀವಿ
ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅದು ಅಡ್ಮಿಷನ್ ಅಂತ ಇದ್ರೊಳಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ರಿ ಅಲ್ವೇ?
ಅದು that was between them, those two. Or even if it was for them to raise that objection, or at least as you said here, that should have been said. We have to see whether they are said.
ಏನ್ ಕ್ಯಾಶ್ ಕೊಟ್ರು ಏನ್ ಕೊಟ್ರು
ಗೊತ್ತಿಲ್ಲ ಬಿಡಿ.
How that caused disadvantage to you, because your rate did not reduce. The only thing now you are trying to say, or you have to show that they were not ready. They have to show that they were ready and willing to perform their part of contract. And you have to demonstrate.
Me saying that here is the balance consideration. No evidence has been laid to show that the plaintiff had the necessary funds in order to execute the sale deed in favor of the defendant. And plus slightly see the payments. First and second vendor get
Fraud and collusion.
all these amounts have been paid.
Leonard Counsel, fraud and collusion. If you say that to play fraud on him, how he was defrauded, that particular has to be pleaded. You were arguing, it appears he has stated in the written statement also. But he is going to get his share of consideration. Even if they execute the sale deed for a lesser price. What was the particular of that fraud? How he was defrauded by that?
Before, kindly see page 186. 185, 186.
ಅಲ್ಲ ನೀವು ನಮ್ಗೊಂದು ಹೇಳಿ ಅಂದ್ರೆ ಏನ್ ಫ್ರಾಡ್ ಆಗಿತ್ತು ಅವ್ರಿಗೆ ನೋಡ್ತೀವಿ ನೀವು ಎರಡು ವರ್ಡ್ ಅಲ್ಲಿ ಅವ್ರ ಇಂಟೆನ್ಷನ್
ಆದ್ರಿಂದ possibly I don't know why, because what is shown in this document is not the actual amount. They must have received in cash later, and that's how they waited for 6 months to execute the sale deed. No, no. What prevented the other two vendors to execute the sale deed in February 2004 itself? If all the entire consideration is to
No,
make,
you should
what will
spell
be
out.
taken?
You should spell out what is the fraud played on you. How ಅದೇನದು fraud?
First is state consideration. 50 ಲಕ್ಷ ಅಂತಿತ್ತು. Sudden ಆಗಿ 25 ಲಕ್ಷ.
ಅಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೇನು ತೊಂದ್ರೆ ಆಗಿಲ್ಲ ಅವ್ರ ಎಷ್ಟು
No, what happens is even my 1/3 share, the value of the property will go down.
how can't turn back
Tomorrow,
You file a suit for damages.
no even if he is others sell to him at a throwaway price, according to the agreement he had to pay your 1/3 share only.
unfortunately, property is bad.
ಡಿವೈಡ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಲ್ಲ ಇದು ಯಾವ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಪ್ರೊವಿಷನ್ ಇದೆ ವಿಚ್ ಇಸ್ ದಟ್ ಪ್ರೊವಿಷನ್ 45. See, if there is no division, it is deemed that they are
Is not there.
no, it is not their case that I have paid substantial amount to them, therefore you are entitled to receive.
Substantial.
ಅಲ್ಲ ರೀ. ಅಲ್ಲ Leonard senior counsel, they are not saying that you are not entitled to anything except that 4 lakhs paid because we have already paid to the other parties. It is not their case. They say that they are ready to pay you the in accordance to your share. Undivided share.
16 lakhs, 66,000, whatever it is.
Correct.
But I'm saying, see the conduct of the play.
We are not able to get you. Please convince us.
See the conduct of
What
the
is the fraud played on you in this transaction?
What played on me in this transaction? Agreement is entered in 4/6/2000. Conversion is obtained on 6/10/2000. Till I cancel the agreement of sale, no amounts are paid to my the appellant. No amounts are paid.
4 lakhs check ಕೊಟ್ಟಿದ್ದಾರೆ.
14 ಲಕ್ಷ.
Ravi said no. Correct. You are not getting that. See,
No, I get what the court is. Court is saying there is a fraud.
what is
If
the
there are three
no?
people.
What is the fraud? You have to spell it. You have to spell it in your written statement.
Enter into a transaction. 3 people have jointly purchased the property. It is out of trust that they purchase the property. Once they enter into an agreement of sale, that's also a question of mutual trust among each other. If the two of them leave out this man, collect all the money, balance money, whatever is to be paid to them, and leave out this man will definitely be defrauded. At that point of time, I will point out as to how property prices are appreciating. So even a 6 months delay won't matter. The board is
See, that may come under their readiness and willingness to perform. If fraud and not concept.
But we do know.
And see, we need not. We need not. No, we need not.
I'm trying to take the case forward. That
Right.
you know the fact that they should have shown the sale consideration as 34 lakhs.
No, Order 6 Rule 4 requires you to plead the particulars of the fraud. What are those particulars of the fraud pleading? All right, it is always. ನಿಮಗೆ ಎಲ್ಲಿ reduce ಮಾಡಕ್ ಸಾಧ್ಯ ಅವ್ರು, and it is not their case that we are going to reduce it to less than 16 lakhs and odd. Now you, all right, you are justified in arguing that they were not ready and willing to pay them and perform their part of contract.
This was the judges to decide, and lawyers we have to.
All right, see, now we have made it clear to you. Proceed to the next point.
Now kindly see exhibit. 14.
No, we should not miss out some point. we should not miss out to some point. ಅದಕ್ಕೆ ನಿಮ್ಮನ್ನು ಕೇಳಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಳ್ತೀವಿ
I
ಅದನ್ನ.
understand, I understand. Exhibit P14 and P17 are the two letters which admittedly he has not been served. Because he himself says some other.
ಆಯ್ತು, that's also admitted. And you already submitted on that.
Issues of public notice which is of no. Oh, kindly turn to this. Starts at it's 28. I will skip, I will go straight away to the reasons. Let's start at page 59.
What is this additional evidence you want to produce?
59, please, that's it.
Correct. Any additional evidence ಹಾಕೋದಕ್ಕೆ ಹಾಕಿದ್ರಲ್ಲ. What is that additional evidence you want?
There are documents.
Which documents? It is filed by you or by them?
No, no,
Appellant.
that's reading already a part of the reports.
Page 7 to 35. Where is the index of that documents?
Please,
ಅಲ್ಲ ರೀ, ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಒಂದು ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಂಡೆಕ್ಸ್ ಹಾಕ್ಬೇಕಲ್ಲ, ಎಲ್ಲಿದೆ? ಪೇಜ್ ನಂಬರ್ ಆದ ತಕ್ಷಣ ಇಲ್ಲ, ಅದು ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ, 7 to 35 ಅಂತ ಇದೆ
index
ಡಾಕ್ಯುಮೆಂಟ್. ಕಾಪಿ ಆಫ್
probably it was filed in court, otherwise they are registering the.
ಇಲ್ಲ, ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲೂ ಕೆಲವೊಂದ್ಸರಿ ಮಾಡ್ತಾರೆ, ಕೆಲವೊಂದ್ಸರಿ ಮಾಡೋದು. ಇಟ್ ಗೋಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇರ್. ಅದಕ್ಕೆ ನಾವು ಕೆಲವೊಂದ್ಸರಿ ಅಂದ್ರೆ ನೋಡಿ, ಯು ಸೆಡ್ ಯು ಹ್ಯಾವ್ ಪ್ರಾಕ್ಟೀಸ್. ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲಿ ಎಷ್ಟು ನೀಟಾಗಿ ಡಾಕ್ಯುಮೆಂಟ್ ಸೀರಿಯಲ್ ನಂಬರ್, ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್, ದೆನ್ ಎನಿ ಸ್ಪೆಷಲ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್, ಪೇಜ್ ನಂಬರ್ ಬರೀಬೇಕು ಈಚ್ ಡಾಕ್ಯುಮೆಂಟ್. ಸೊ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ ಅಸ್ ಟು ಲೇ ಅವರ್ ಫಿಂಗರ್ಸ್ ಆನ್ ದಟ್.
One is the original list of documents, it is there, page 7.
The
Page 7.
sale deed of these vendors. First one is sale deed of vendors. Second one is 1992 executed by Murthy in favor of Bharati. Copy of deed of absolute sale deed dated 13/8/2004 by Narsimaya and Bharati in favor of
That is already.
Madhavi Dudhwal. Then why are you producing it?
That is already. There is no document.
How they got the property.
They are all admitted facts. Sir.
Not necessary.
Demonstrate that even in the same their favor, there was no division. It was
It was an admitted fact, alva. They had an undivided. Okay. ಆಯ್ತು, ಅದಕ್ಕೆ ಒಂದ್ಸರಿ ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ.
Another, their previous period, how they got the property. Neither the operator.
Oh, this was filed in 2011 itself. ಆಯ್ತು ಆಯ್ತು, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅದ್ರ ಮೇಲೆ, ಅದಕ್ಕೆ is either civil or criminal. Point, what is the point in controversy ಅಂತ ಒಂದು ಪಾಯಿಂಟ್ ಫಾರ್ಮ್ಯುಲೇಟ್ ಮಾಡ್ಕೊಂಡು, ಇವನ್ ಅಟ್ ದ ಬಾರ್ ಅದಕ್ಕೆ ರೆಲೆವೆಂಟ್ ಇರೋ ಲಾ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಂತ ಅಷ್ಟೇ ಮಾಡಿದ್ರೆ ಅದು. ಬಿಕಾಸ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವರ್ some of these were, all of these were admitted facts. One of the document was there already on record. ಈಗ ಕೋರ್ಟ್ ಇನ್ನೊಂದ್ಸರಿ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ಬೇಕು ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಬರೆಯೋದಕ್ಕೆ.
Document is the original document is how they read.
Correct. See, that was an admitted fact. ಆಯ್ತು, but we are not saying only with reference to this case. Civil case ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಉಳಿತಾವ ಅಂದ್ರೆ ಈ ತರ.
See all the documents, see the evidence on the record, see the pleading.
See all the documents produced before the trial court. Order 41 rule 27 is conditional.
I agree. That is the distinction of the court.
Not discretion. Those three conditions have to be satisfied.
Why you could not produce it earlier?
Yeah,
All that is.
Otherwise, it should be the requirement. Otherwise, it should be the
I
requirement.
understand. Possibly these documents may not be relevant. Already, nobody.
That's what.
Only for the limited purpose that no shares were defined.
You have to train your bar members accordingly.
Paragraph 17, page 39.
Yes.
The case of the plaintiffs that the defendant being one of the owners of the suitable property executed the agreement of sale in favor of the plaintiffs along with two co-sharers. Two co-sharers have executed the sale deed in favor of the plaintiffs in respect of their one-third share each. However, the defendant being the one-third sharer of the suitable property has failed to execute the sale deed in favor of the plaintiff by virtue of the agreement of sale dated 6/3/2003. The case of the defendant that he had entered into an agreement to sale of his one-third share in favor of the plaintiffs, but the agreement was rescinded since the plaintiffs have failed to get the sale deed registered in the and hence agreement of sale is not enforced. In further case of the defendant, that the plaintiff failed to get the sale deed registered in their name within the stipulated time. In view of the rival contention and proves the evidence. According to the plaintiffs, the defendant is entitled to 16,66,000 a sale consideration share, in which a sum of 4 lakhs was paid to the defendant as part of it. In further case of the plaintiff, that another 4,000 cash was paid towards the sale consideration jointly to all of them. On perusal of the agreement is marked as Exhibit P2. It discloses the defendant and two other persons by name Narasimha and Bharat have entered into an agreement of sale of the suitable property in favor of the plaintiffs under the deed dated 6/3/2003. Paragraph 3 of the written statement, the defendant has unequally admitted that all the three persons named Narasimha, H.S. Bharti and defendant jointly agreed to sell the suitable property for a total sale consideration. Total sale consideration of rupees 50 lakhs and receive some advance under the said agreement. The admission by the defendant himself is sufficient to hold. The defendant had executed the agreement of sale in favor of the plaintiff, along with Narasimha and Srimati H.S. Bharti. Moreover, there is no such dispute regarding the execution. However, the plaintiffs are contending the suitable property was delivered to the possession of the plaintiff. They are in possession of the suitable. It is also contended that the plaintiffs have made improvements in the suitable. On perusal of Exhibit P2, it clearly shows that there is no such insight in respect of the delivery of the property as of the date of agreement of sale. The condition number 5 of Exhibit P2 reads as follows. The vendors have agreed to hand over possession of the property to purchasers or their nominees. No doubt Narasimha and H.S. Bharti have executed the sale deed in favor of the plaintiffs in respect of their one-third share each. Therefore, they have delivered possession to their one-third share each as on the date of the sale deed executed by them and not on the date of the sale. It is not in dispute that the defendant has not executed the sale deed in favor. Therefore, the recital itself is clear that possession of one-third share of the sale remained with the defendant. The entire oral evidence adduced by the plaintiff discloses that nowhere the defendant has admitted the delivery of his possession and nothing is elicited to show that the possession of the property was delivered to the plaintiff, except some photograph marked as it will be P24 to P27. Nothing is brought on record to show that delivery of possession of property to the plaintiffs. The photographs produced by the plaintiff disclose that some properties, but there is no evidence on record to show that plaintiffs are in possession of the property shown in Exhibit P24. The plaintiffs have taken up the contention that they have made improvements in the suitable property like sinking borewell and construction of shed, etc. Nothing is produced to show that the plaintiffs have made improvement in the suitable property. Therefore, I find no evidence on record regarding delivery of possession. It is the apprehension of the plaintiffs that the defendant is trying to eliminate the suitable property. The tenor of the defense, as well as the conduct of the defendant, in not executing the sale deed in by virtue of exhibit P2, itself shows that there are every chances for the defendant alienating the suit schedule property to third party during the subsistence of the exhibit P2 agreement of sale. However, the question of interference by the defendant does not arise, since the plaintiff has failed to his position over the suit schedule property. Therefore, I answer issue number 1 in the affirmative and issue number 3 in the negative. I also answer issue number 4 in partly in the affirmative, holding that the defendant is trying to eliminate the suit schedule property. This is the learned judge arrives at this conclusion only because the defendant refuses to execute this, and no other material is used.
That is regarding execution of the document.
Previous sentence. It itself shows that there are any chances. That is how the learned judge arrives. Hence, issue number 4 partly in the affirmative. Issue number 2 and additional issue number 4. These issues are taken up together for consideration to avoid repetition of facts as they are all interrelated. The plaintiffs have contended that they are always ready and willing to perform their part. However, the defendant has contended the time is essence of the contract and hence the plaintiffs have failed to get the same deed registered in their name within the stipulated period of 6 months. I will skip this paragraph 24. 25. Therefore, it is necessary to the plaintiff to plead and prove that they were ready and willing to perform their part of the agreement. It is not been disputed that the defendant has executed the agreement of sale. Exhibit P7 and P8 of the draft sale deeds, which were prepared by the plaintiffs for sale of the suit schedule property. And both exhibit P7 and P8 are signed by CH-5 and Narasimhan. Pause here. These documents, these two draft sale deeds, would have been created for the purpose of the suit, because those two vendors were always supporting the plaintiff. No relevance can be placed on those two documents because he admits the fact that the letter was sent to another address. This defendant had no idea, defendant had no idea about the sale. PW3 is one of the witnesses examining of the plaintiff and has admitted the execution of that sale. Therefore, the plaintiff was expected to pay the balance sale consideration to the defendant and to get the sale deed executed. No letter from the defendant saying that I'm tendering this money, please come and execute the sale. He files the suit also no, and even in the suit he does not deposit the amount. Plaintiff has made his effort to get the sale deed registered in his name, but it was denied and refused. Nowhere such contention is taken in the written statement that the plaintiffs have got no financial capacity to pay the balance sale consideration to the defendant. The pleadings as well as the evidence, I'll skip the next paragraph, 27. The sale deed was executed by Narasimhan and Bharti under deed dated 30/8/2004 under exhibit P23 in respect of the share in the property in favor of the plaintiffs. The plaintiffs were paid the balance of the sale consideration in terms of the agreement exhibit P2. This itself shows that plaintiff had sufficient money to pay the defendant also. The evidence, this is for saying that plaintiff had sufficient. The evidence on record coupled with exhibit P23 sale deed executed by Narasimhan and HS Party discloses that the plaintiffs have paid 2/3 of the amount to Narasimhan and Srimati Bharti. That was the reason why I pointed out that's registered sale deed. 2/3 of private other prakara bari 23 laksha. Entire sale consideration, other 14 laksha used. Therefore, there was no difficulty for them to pay the share of the defendant, who is one of the executors of the sale deed by name Narasimhan, is the person who executed the sale deed in respect of his 1/3 share has supported the case of the plaintiff. Let's keep all this. And again, go to page paragraph 36. 35 last two sessions. Moreover, the plaintiffs have paid. Plaintiffs have paid the entire sale consideration to the other two co-owners in respect of their shares. Moreover, the plaintiffs have paid rupees 4 lakhs to the defendant as part consideration amount in respect of the purchase of the suit scheduled property. Viewed from any angle, there is sufficient evidence of record that the plaintiffs are ready and willing to perform their part of the contract. During the pendency of the suit, the plaintiff number 1 is reported to be dead. Therefore, plaintiff number 2 being the party to the agreement of sale proceeded with the case. Therefore, plaintiff number 2 has got only right to prosecute the case against the defendant in view of the agreement of sale. Moreover, plaintiff number 2, none other than the deceased son of deceased was in the cross-examination of PW1 has admitted that the recital in the exhibit that the sale deed had to be executed within 6 months. Even PW2 has admitted that the recital in the exhibit the time limit of sale deed is 6 months from the date of agreement. However, the witness volunteers in the sale agreement, he stated the time is not the essence. PW2 has stated they have not issued the notice to the defendant during the period of 6 months or in the execution of sale deed expressing readiness. He admitted that they received the notice from the defendant in 6 months. As per exhibit 4, for that notice, the plaintiff replied as per exhibit 5. In exhibit 5 issued by the defendant, it is clearly admitted that on 3/2003, an agreement came into existence. He has further stated in the notice that the time stipulated in the agreement or completion of sale transaction was 6 months from the date of agreement. It is further evident in the notice issued by the defendant that plaintiffs have not bothered to get the sale transaction within the stipulated time, and thereby plaintiff lost the right to call upon the vendors, including the defendant, to sell the substitute property. Therefore, the question arises whether issuance of notice receiving the contract is sufficient to hold the defendant is not liable to execute the sale deed. In view of this, I will use the exhibit in which the last line of the petition of the shows that wherever receiving cash of advance have agreed to receive the balance at the time of execution of the sale deed within 6 months from the date thereof. Therefore, it is clear that the normal time is 6 months. But at the same time, very next condition, time is not the essence of the contract, as some formalities have been gone through and they involve time. It was here. Firstly, the learned judge does not state anywhere, he goes off on the time. When a notice is issued saying that I am rescinding the agreement, you are not ready and willing to execute. He should have tendered the money or said, I am willing to get the same notice. Whoever went. And the learned judge also loses sight of the fact. And furthermore, he says, condition number 4 essential, that is not the issue. And some formalities for over on 610, plaintiff himself produces the document, in the light of which the agreement should have been executed on 7/10/2000, sale should have been executed on 7th or 8th of October 2003. Under these circumstances, it is clear that though the parties with intention that the sale deed is executed within 6 months, they apprehend, the judges apprehend, they apprehend that some formalities have to be gone through and they involve time, and hence time is not the essence of the contract. In the case of the defendant is to believe that the sale deed is executed within 6 months, then he could not have signed execution. When there is a condition in itself, the time is not the essence. He has not refused to sign the agreement. When there is a recital in the agreement, the time is not the essence of the contract. Therefore, the contention of the defendant cannot be given that the time stipulated for the execution of sale deed is only 6 months. I am not going to court. It is the plaintiff who has come to court. It is for the plaintiff to his case. You cannot depend on the weakness of the case of the defendant. The agreement itself discloses that it was the intention of the parties that if the sale deed is executed within 6 months, then it is well under. I don't know where the learned gets this well under. But on the same time, they have agreed for the condition that time is not the essence of the contract. Therefore, I find that plaintiffs have proved that they are always ready and willing to perform their part of the contract. I also hold that time is not the essence in terms of execution. Therefore, I answer issue in the affirmative and additional number issue number 4 in the negative. Let me see the agreement.
Yes, yes, it is not. Yes, it-
Lastly, agreed to receive the balance at the within 6 months from the date I give out. Again. Paragraph 39. Much effort is made in the cross-examination period of 1 to 3 to show that no notice was served to the defendant regarding the readiness and willingness of the PW who steps into the box says, we have not sent any. I don't need to prove it. However, it is within the knowledge of the defendant that an agreement came into force. Nobody is denying this. Therefore, mere issuing letter by the defendant to the plaintiff that he has rescinded the contract is not sufficient to absolve his liability. The learned judge proceeds on the premise that the burden was on the defendant to show. Please case. So he goes about between the suit directing the plaintiff to deposit the remaining consideration of 12,66,660.
Yeah, last operative portion in the defendant is directed to execute the sale deed in suitable property in favor of the plaintiffs within 1 month from the date of deposit of it. Plaintiffs are directed to deposit remaining 12,66,667 within 1 month. Are deposited before this. Right.
No.
First read the second judgment.
ಅವ್ರದಕ್ಕೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲ ನಿಮ್ದಕ್ಕೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರ See, now what you serve is not what you serve is not most important. How you present it, how you serve it is most important in the present world. Yes, yes, exactly. How you present it ಅಂತ
ಸ್ಟಾರ್ ಹೋಟೆಲ್ಗೆ ನೀವು ರಸ್ತೆ ಬದಿ ದರ್ಶನಿಗೆ ಹೋದ್ರೆ ಹಂಗೆ ಇರುತ್ತೆ. ಸ್ಟಾರ್ ಹೋಟೆಲ್ ಹೋದ್ರೆ ಅದಕ್ಕೇನೆ
by engaging a senior correct by engaging a senior counsel, no, they have gone to Star Hotel only. So at least they have to assist.
What has happened is my friend who is the advocate on record is not well, so.
Who is the advocate?
Yes,
Okay, here, but henceforth, ನೀವು That document is produced by your Shanmukappa only. List of documents, IA 1 of 2011 ನಲ್ಲಿ additional document. ಅವರು ಹಾಕಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ನೀವೇ ಕೊಟ್ಟಿದ್ರೆ ಅಲ್ಲ, ಅದು ಈಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಂದು ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಅಲ್ಲ ಆ ಪ್ರಕಾರ ಕೊಟ್ಟಿಲ್ಲ. 7 ಅಲ್ಲಿ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. ಅದಕ್ಕೆ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸೀರಿಯಲ್ ನಂಬರ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಮುಂದೆ ಅದು ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಬರೀಬೇಕಲ್ಲ. ನೋಡಿ.
Sorry, the second judgment, 2010. This is Ravindra's judgment.
Mankaur's case.
It's 514, head note C.
514. Second and first. Yes.
Indira Bannerjee is just Indira Bannerjee is the first one.
ನಮಗ್ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಅವ್ರದ್ದು ಫಸ್ಟ್ ಒನ್.
First one. My friend said the reverse side.
No.
First judgment.
Whichever you want to refer, you can.
No, first I read Justice Ravindra's judgment because it's earlier in point.
Okay.
This is when the act existed then.
514.
514, head note C.
Yes.
Contract and specific relief act. Specific performance of contract, readiness and willingness to perform, burden of proof reiterated. Plaintiff should not only plead and the terms of the agreement, but it should also plead and prove his readiness and willingness to perform his obligation under the contract, in terms of the contract. It not the contract and specific performance of contract, readiness and willingness to perform, existence and of refusal by defendant to perform, hence does not obviate need of plaintiff to have readiness and willingness to perform. Here, defendant refused. The plaintiff, the burden is on the plaintiff, even then to admit that the assumption that readiness and willingness on the part of the plaintiff is something which need not be proved. If the plaintiff is able to establish that the defendant refused to execute the sale deed and thereby committed breach is not correct. Take a case when there is a contract to sale for a consideration of ₹10 lakhs, and unless money of ₹1 lakh was paid and the vendor wrongly refuses to execute the sale deed unless the purchaser is ready to pay ₹15 lakhs. In such a case, there is a clear breach by the defendant. But in that case, if the plaintiff did not have the balance 10 lakhs and the money required for stamp duty and registration, or the capacity to pay, to arrange and pay such money, then the contract has to be performed. The plaintiff will not be entitled to specific performance, even if he proves breach by the defendant, as he was not ready and willing to perform his obligation. Page 515, in the first paragraph. Succeed in a suit of performance, the plaintiff has to prove that a valid agreement of sale was entered into by the defendant, his favor and that the terms thereof, that the defendant committed breach of the contract, and that he was always ready and willing to perform this part of the obligation in terms of the contract. Next paragraph I say, but there they say there need not be even a clause that specific performance should be there. It is telling the court again. Kindly turn to page 520. Paragraph 30. They quote a judgment of the Supreme Court itself reported in SCC. The continuous readiness and willingness on the part of the plaintiff is a condition precedent to grant the relief of state. This circumstance is material and relevant and is required to be considered by the court by granting or refusing to grant the relief. If the plaintiff fails either to ever or prove the same, he must fail to adjudge whether the plaintiff is ready and willing to perform his part of the contract. The court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances the amount of consideration which he has to pay to the defendant must of necessity be proved to be available right from the date of execution till the date of the decree. He must prove that he is ready and has always been willing to perform his part of the contract. As stated, the factum of his readiness and willingness to perform his part of the contract is to be adjudged with reference to the conduct of the party and the attending circumstances. The court may infer from the facts and circumstances whether the plaintiff was ready and always ready and willing to perform his part of the contract. It's 525, paragraph 22. The respondent relied upon the following observations of this court in so and so. It is indisputable that in a suit for specific performance of contract, the plaintiff must establish his readiness and willingness to perform his part of the contract. The readiness and willingness on the part of the plaintiff to perform his part of the contract would also depend upon the question as to whether the defendant did everything which was required of him to be done in terms of the agreement for sale. Here, permission had to be obtained for conversion. That was granted as early as 6/10/2000. So all the formalities were completed within a period of 7 months. The question as to whether the onus was discharged by the plaintiff or not will depend upon the facts and circumstances of each case. No straitjacket formula can be laid down in this behalf. In the next one, paragraph 23. The basic principle behind section 16C read with explanation is that any person seeking benefit of the specific performance of contract must manifest that his conduct has been blemishless throughout, entitling him to the specific relief. Why I am stressing on this sentence once again. The court posed the question as to why the sale deed was the consideration is conduct has to be blemishless. Provisions impose a personal bar. The court is to grant relief on the basis of the conduct of the person seeking relief. If the pleadings manifest that the conduct of the plaintiff entitled him to get relief, on perusal of the plaintiff, he should not be denied the relief. The court further held, this court further held that the elements relating to readiness and willingness are not a mathematical formula which should be expressed in specific terms. And if the government in the plaintiff as a whole to clearly indicate the readiness and willingness of the plaintiff is part of the obligations under the contract, the fact that the wording was different will not vitiate against the readiness and willingness of the plaintiff. The above observation cannot be construed as requiring only a pleading in regard to the willingness. In fact, in the very next paragraph, this court clarified that section 16C of the Act mandates that the plaintiff cover in the plaintiff and establish the fact by evidence that he has always been ready and willing to perform his part of the contract. Therefore, the decision merely reiterates the need for both pleadings and proof in regard to readiness and willingness of the plaintiff. This contention has no merit. There are two great issues. The first issue is the breach by the defendant vendor, which gives a cause of action to the plaintiff to file a suit for dispute. February 2004, the defendant refused to execute the same. The plaintiff should have come to court immediately. He doesn't choose. That is the point which is called consider. The second issue relates to the personal part of enforcement of a specific performance by persons enumerated in section 16 of the contract. A person who fails to ever prove that he has performed or has always been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than the terms the performance of which has been prevented or waived by the defendant, is barred from claiming specific performance. Therefore, even assuming that the defendant had committed breach, if the plaintiff fails to aver in the plaint or prove that he was ready and willing to perform the essential terms of the contract, which are required to be performed by him, other than the terms of the preference of which he was prevented or waived by the plaintiff, there is a bar to specific performance in his favor. Therefore, the assumption of the respondent that readiness and willingness on the part of the plaintiff is something which need not be proved if the plaintiff is able to establish that the defendant refused to execute the sale deed and thereby committed breach is not correct. Let us give an example. Thank you. That same I did that. In such a case, there is a clear breach. Kindly take the next judgment. We are 20, recent judgment of last year. We turn to you. Before the numbers are below. Before paragraph 21 is well settled that in the suit for specific performance of the activity, it is for the plaintiff to prove his readiness and willingness to perform his obligations under the law. When a certain amount has been paid in advance and the balance is required to be paid in this stipulated time, it is for the plaintiff to show that he was in a position to pay the money. The plaintiff has to prove that he has the money and alternatively made necessary arrangements. In this case, the original appellants, defendant stroke appellants have all along contended that the plaintiff respondent neither offered to pay nor was in a position to pay the balance consideration of these 15 lakhs. And again, paragraph 25. Whoever and prove readiness and willingness to perform an obligation to pay money in terms of the contract, the plaintiff would have to make specific statements in the claim and adduce evidence to show availability of funds to make payment in terms of the contract in time. In other words, the plaintiff would have to plead that the plaintiff had sufficient funds or he was in a position to raise funds in time to discharge his obligation under the contract. If the plaintiff does not have sufficient funds with him to discharge his obligation in terms of the contract which require payment of money, the plaintiff should have to fiscally plead how the funds should be available to him. To cite an example, the plaintiff may aver and prove by adducing evidence an arrangement with the financier for disbursement of adequate funds for timely compliance with the terms and conditions of the contract involving payment of money. Mankaur versus Hattar Singh Singha, this court held that a person who fails to aver and prove that he has performed and has always been ready and
That is again same Justice Ravindran's judgment.
this is the same.
That is same extracted.
Sorry, right. Next one is the real policy. Paragraph 28. Real housing, paragraph 27. Premraj versus real housing. Cited by Mr. Venugopal, this court speaking to Ramaswamy J. held that it is well settled that it is suit for specific performance. The plaintiff should allege that he is ready and willing to perform his part of the contract. And if the fact is false, he is required to continuous readiness and willingness from the date of the contract to the time of the hearing to perform the contract on his part. The Supreme Court will go further and say that the date of the decree even continues. For such question, the learned judge relied upon the opinion of Lord Lansborough in Ardishe so. In the absence of an averment on the part of the party, he was ready here. The question is whether the respondent plaintiff has proved his readiness and willingness to perform his obligations under the contract. This court reiterated that section 16C of the specific Legal Act 1963. It is suggested that the plaintiff must plead and prove that he has performed or has always been ready to perform the essential terms of the contract, which were to be performed by him, other than those terms, the performance which has been implemented or made in MP Tirugaram, this court has said that the continuous and readiness and willingness of the part of the plaintiff was a condition precedent to grant the relief of specific performance. And again, paragraph 31. So far, there being a plea that they were ready and willing to perform their part of the contract is there in the pleading. We have no hesitation to conclude that this by itself is not sufficient to hold that the appellants were ready and willing in terms of section 16C of the Specific Pleading Act. This requires not only such plea but also proof of the same. Now, examining the first of the circumstances, how could mere filing of this exemption was granted be a circumstance of the willingness or readiness of the plaintiff? This at the most would be the desire of the plaintiff to have his property. It may be for such a desire, this suit was filed raising such a plea. But section 16C of the Act makes it clear that mere plea is not sufficient. It has to be proved. In Vidyanandam versus Bhairavan, Justice P.P. Jeevan Reddy said that grant of the relief of specific performance is discretionary and the court is not bound to grant it. This court further held that though time is not the essence of the contract relating to transfer of property, such contracts need to be completed within the reasonable time period. Thus, the time element cannot be completely ignored. Again, the next page, paragraph 35. Even in first appeal, the first appellate court is duty bound to examine whether there was continuous and readiness and willingness on the part of the plaintiff to perform the contract. This proposition finds support for various. It is well settled position of law that an appeal is a continuation of the proceedings of the court. Ordinarily, the appellate jurisdiction involves a rehearing of law as well as fact and is invoked by an aggrieved person. First appeal is a valuable right of the appellate, and therein all questions of fact and law decided by the trial court are open for consideration, reconsideration. Therefore, the first appellate court is required to address itself to all the issues and decide the case by giving reasons. The court of first appeal must record its findings only after dealing with all issues of law as well as fact, and with the evidence oral as well as documented read by the party. The judgment of the first appellate court must display conscious application of mind and record findings supported by reasons on all issues and contentions. Paragraph 38, what I stated earlier orally, this is stated here. In this case, we cannot overlook the fact that the suit property is located in the industrial town of Kostu, located about 30-40 kilometers from Bengaluru. The court is obliged to take judicial notice and request this order to take judicial notice of the fact that the property is situated 22 kilometers from Bengaluru. The phenomenal rise in the price of real estate in Mysore. The proposition finds support from the case reported in so and so. To quote this quote, we cannot be obvious to reality, and the reality is constant and continuous rise in the values of urban properties, fueled by large-scale migration of people from rural areas to urban centers and by inflation. Paragraph 39, that 37 report that Sardamani Kandappan versus Rajalakshmi. The reality arising from this economic change cannot continue to be ignored in deciding cases related to specific performance. The steep increase in prices is the circumstance which makes it inequitable to grant the relief of specific performance, where the purchaser does not take steps to complete the sale within the agreed period, and the vendor has not been responsible for any delay or not. The purchaser can no longer take shelter under the principle that time is not the end of essence in performance of contracts relating to cover his delay batches, wheelchairs and non-ready. The precedents from an era when high inflation was unknown, holding that time is not the essence of contract in regard to moving properties, may no longer apply. Not because the principle laid down therein is erroneous, but the circumstances that existed when the said principle was evolved no longer exist. In these days of galloping increases in prices of immovable properties, to hold that the vendor takes an unnecessary deposit of funds, adding to the misery the delay in disposal of case related to this. As suits and appeals therefrom routinely take 2 to 3 decades to attain finality. As a result, an owner agreeing to sell a property for ₹1 lakh and receiving ₹10,000 as advance may be required to execute the sale deed a quarter century later by receiving the remaining ₹90,000 and the property has risen to. Again, at paragraph 43, the quote is and then again 44. Here there was 3 years. Here what I am saying is 1 year, 8 months, 9 months in 5 years. 1 year, 9 months after the agreement to sale the
But this galloping prices 16C ge is it in consonance with 16C?
Present act
Yeah.
ಅಲ್ಲಿ.
This is what the apex court is.
Yeah.
Correct, apex court.
Present act ಅಲ್ಲಂತೂ ಇಲ್ವೇ ಇಲ್ಲ ಅದು.
Galloping price. No, in the sense.
See, hardship ಅಷ್ಟೇ hardship ಗೆ ಅದನ್ನ consider. Because in some of these- Probably might have gone correct. So we have seen in some of the cases, additional fee was, additional consideration was ordered to be paid. In some of these cases, additional consideration ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ. ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ, ಅಡಿಷನಲ್ ಕನ್ಸಿಡರೇಷನ್ ಕೊಡಿಸಿದ್ದಾರೆ.
Surely the readiness and willingness by producing materials, all that. Here at paragraph 45, the respondent plaintiff has relied upon the notice dated 13 and evidence of PWD to prove that he was always ready to perform his part of the contract.
Yes. No, just we are discussing on that.
Sorry. Even though it may be true that the respondent here it is deposited
Where are you
in
reading?
the paragraph 45.
45. Plaintiff has deposited balance.
Here it is deposited, but no arrangements, no, this thing was shown to the, yes, pay the balance and consideration. Paragraph 46. It is settled law that for relief of specific performance, the plaintiff has proved that all along, until the final decision of the suit, he was ready and willing to perform his part of the contract. It is the bounden duty of the plaintiff to his readiness and willingness by reducing the. This crucial facet has to be determined by considering all circumstances, including availability of funds, and mere statement or averment in plaint of readiness and willingness would not suffice.
That is time and again, very pleading is not sufficient. And has to prove, the section itself made it imperative that they have to prove their readiness and willingness.
And the court also says, 45 below the court addition, deposit of any amount in court at the appellate stage by the plaintiffs not establish their ready and willingness to perform their part of the contract within the meaning of section 16C of the section.
45.
Last 3 lines. Next cited the same. 47 and Calgary 45.
47 ನಲ್ಲಿ ಕೆಳಗಡೆ.
Paragraph 47. Calgary.
All right. Yes.
And again at paragraph 50. Again say that. Okay, that was scary. And 3 years. Oh. After summer. Came to be enter 6. Conversion activity. Plaintiff produces a document. 6th of October 2003, it's a conversion. Admittedly, no evidence has been made to show that he had the necessary funds to execute. Just because he executes the sale deed in favor of other two vendors, that too after a period of nearly 16 months, that cannot be the criteria to demonstrate that he had the funds and readiness and it is for the first time after the defendant receives the contract with the plaintiff makes up. There has been, admittedly, there has been no letter by him or any correspondent stating that here are the funds, please come and execute the same. Even after he receives the legal notice in February 2000, he does not choose to receive. And neither will he file the suit, he doesn't produce any material to show that he has the necessary. And till the date of the decree, according to the judgments of the Apex Court, he had to show that he had the necessary funds. And even the appeal is a continuation, there is submission. The learned judge proceeds on a wrong premise, and plus, the learned judge said just because those two sale deeds were executed, he was ready and willing. He does not go into the fact. They're just averring that readiness and willingness is not enough. No material is produced. And plus, blemishless conduct is what's that sale deed I would press for the simple reason that the conduct of the plaintiff in the circumstances, appeal is the allowed and the right of the
They have not disputed that you have pleaded. Come to the next.
Even in the written statement, the defendant has not dispute, has not taken contention that the plaintiff is not in a position to pay balance consideration and sufficient money for the release of conflict settlement. It is very important. Defendant has not taken consideration. I will go to the documents now. The agreement is 6th March 2003. Item number 3. In consideration of vendors have received 8 lakh rated bearing number, etc. We have that word place there. Have agreed to receive balance at the time of execution of the sale date. This is very important. Point number 2. Time is not the essence of the contract as some formalities we want to have a involved time. So time is not the essence of the contract. Now, I will kindly come to try exhibit P3. Conversion order is very important. The conversion order, figure number 4. Narasimhaya Krishna ಮತ್ತು ಶ್ರೀಮತಿ ಎಸ್ ಭಾರತಿ ಅವರು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ ಅಕ್ಟೋಬರ್ 7, 2003. So agreement dated is 6/3/2003. They are applied conversion on 10/7/2003. Conversion granted on 6/10/2003. October 6/10/2003 by that. Because it is well settled. The conversion only in the name of the vendor how to be applied. Whatever the expenses the plaintiff has incurred, unfortunately, we did not get the receipt from we paid conversion fee. and the amount of paid to the defendant is paid to the treasury. It is the provision. Thereafter, 6/10/2003 is the conversion. Nearly 7 months have taken the already sufficient time. The actual date of the sale was fixed on 9th February 2000. Even before he retained the contract before. The defendant has no authority to cancel the agreement with us. The agreement time is not the essence of the contract. It is very important. The agreement must be executed within 6 months only. Then the condition number time is not the essence of the contract. Then the sale deed should have been executed within 6 months only. In this class, this is the time is not the essence of the contract to perform their contract to execute the sale deed in favor of the purchaser, that is the plaintiff. Even before the sale deed or the date was fixed, he himself decided the contract. How can he contract? He should have write a letter. Not paid this balance sale consideration and also not to obtain sale deed. Therefore, the sale deed is into the contract. It is not at all not done. In the exhibit 4, the plaintiff replied, I have received your notice dated 6/2004 in connection with the above on behalf of the it is true that under agreement dated 6/2003, your client and other two owners agreed to sell land to my father and me for further consideration of 50 lakhs. Each share of 50 lakhs into 6,000. The defendant are declared that the amount is not mentioned. Each share there are 3%. 3% are entitled for 16 lakhs, 15 lakhs, 15 lakhs. Initially, the land has been converted for residential use and later converted for commercial purposes and repaid is paid 1,50,000 towards only conversion fee, 700 etc. Because the accepted now. There is no dispute as to advance amount is due by the apparent defendant. Thereafter, the defendant is concerned. Return is accepted is not a cost is already because even today it is dependent on you. For that, advance amount is dependent on you. Thereafter, the month of June 2004, the draft sale deed was prepared and rated in the submission office. It did not come. After the cancellation of the agreement, the defendant never performed his never appeared before the proceedings. For that purpose, the plaintiff issued a notice dated exhibit P9 August 2004. You along with SS Bharati Dada of Vijay Goda, resident of Alasul village, Nasimaya Sana, resided at Punya, Bengaluru, joined the one for the Punya 21, including 2 acres of land in survey number 102.
Where are you reading? Where are you reading?
It will be easier to LCR.
P9. P9? P9. Oh. P9 is certificate notice. Certificate of posting. P9 is notice. P9 is notice.
August 2004, page number 167.
How much time will it take? Next time ಬೇಕಾಗ್ಬೋದು ನಿಮ್ಗೆ. 3 ಗಂಟೆ ಆದ್ರೆ ನಾಳೆನೇ ಮಾಡಿ. ನಾಳೆ ಫಸ್ಟ್ ಆಫ್ ಟುಮಾರೋ. ಅವ್ರು ಮಾಡೋದಷ್ಟೇ ಅಲ್ವಾ? ರಿಪ್ಲೈ ರೈಟ್. ಅಲ್ಲ ಈಗ ನಾವು ತಗೊಂಡ್ರು ನಾವು ಇಟ್ ಇಸ್ 4:37. ಅರ್ಧ ಗಂಟೆ ಬೇಕು ಅಂತಾರೆ ಅವ್ರು. ವಿಲ್ ನಾಟ್ ಬಿ ಏಬಲ್ ಟು. ಲೆಟ್ ಯುವರ್ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್. So we'll have it tomorrow then, because as we say, wherever we take, no, we want to come.
I'm only making a request.
Correct. He can make note of that. If you want to reply, he can reply in the next
If there
day.
is anything by way of rejoining, then I will.
Shri Science and Leonard Senior Counsel for the advocate on record for the appellant. And Shri so and so for respondent in part. For further hearing as it will the list tomorrow. Nale. First ನಾಳೆ ಪಾಠ ಅವರು ಬಂದಿರ್ಲಿಲ್ಲ, ಇವ್ರು ಮಾಡಿದ್ರು ಅವ್ರು ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ. ಆಯ್ತು ಇರ್ಲಿ ಆದ್ರೂ ಅವರು ಬರ್ತಾರೆ ಬಿಡ್ತಾರೆ ಗೊತ್ತಿರೋದಿಲ್ಲ, ನಿಮ್ದೇ ತಗೊಳ್ತೀವಿ ನಾವು. ಪಾಠ ಮಾತ್ರ ಟಾಪ್ ಅಲ್ಲಿ ಹಾಕಿಸ್ಕೊಂಡು ತಗೊಳ್ತಾ ಇದ್ವಿ. ನಿಮ್ದೇ ಓಲ್ಡರ್, ನಿಮ್ದು ಓಲ್ಡರ್ ಕೇಸ್ ಇದ್ರೆ ಪಾಠಡಲ್ಲೂ ಫಸ್ಟ್ ನಿಮ್ದೇ ಬರುತ್ತೆ.
Number 21. Number 21. In Maharashtra.
Kೃಷ್ಣ ರೇಖ ಇರೋರಲ್ಲ. Adjournment.
22. Dinesh Kumar Kera.
No representation for appellant adjourned.
Number 24.
Harish Bhandari is not there in this. No representation for the respondent adjourned. Really connected hundred. There are 3. ಎರಡರಲ್ಲಿ ಅವರು ರೆಸ್ಪಾಂಡ್. ನೋಟ್ಸ್ ನನ್ನ ನೋಟ್ಸ್ ಜಾಸ್ತಿ ಮಾಡಿಲ್ಲ.
Sir.